item 7, the contempt petition. Lord, this was moved, item 7, this was moved by the other side apparently without informing us. Original date was 28th, which is next Friday. In fact, the Honorable Supreme Court had stayed the interim orders and in fact passed an order which I can pass on to my lords.
This is that question.
This is that matter. My lords recollects the two children, Goa and Bangalore. And after my lords, in fact, last April passed an order. That order, the Honorable Supreme Court stayed it. Children have been with me. I'm for the father. From last April, May, children have been with me. Now, the Honorable Supreme Court has said to expedite and to hear it within 6 weeks.
Preferably
We have no
within 6 weeks.
difficulty. My only issue is, my lords, matter date was 28th. I was under the impression 28th is there. We want to file an additional affidavit with an update of the situation now. I believe the other side got it listed after mentioning, if only we were told we could have taken a joint date together. That's all. I just want to request, it can be kept on 28th. We will argue the matter. I want to file my updated statement of what has been happening for the last date. I have no difficulty, but I cannot be taken unawares. Matter is suddenly listed today.
Which petition?
This, my lord, there are 3 petitions. Item number 7. 1 minute, ma'am. 7.
No. The Honorable Supreme Court said that we directed the High Court shall decide the contempt petition.
As well as writ petition. We had filed 2 writ petitions. They are both listed together. Both parties.
Which is that writ?
My lords, they are here. They are all listed together.
They all tagged together. Yes.
No.
Different bench.
No, they are all listed together. They were all brought here. So all the 2 writ petitions are filed because both parents challenged the interim custody order of the family court. We also filed a contempt. Then ultimately, my lords clubbed all 3 matters together. Even those writ petitions were brought here. So they are all together. Ultimately, my lords, we are ready to argue the matter. It may just take 1 date of arguments, but we want to, from the last 10 months, what has been happening? I need at least 3-4 days time to file my updated affidavit. Date was given on 28th. My friend has no difficulty with 28th.
So 6 weeks from today means it is already there.
No, it is till mid-March, but we'll finish. I don't think if my lords keeps it even at 2:30 or something, so that matter can be heard, no further adjournment. It will just give me 4-5 days time to file my additional affidavit of 10 months what has happened. If 28, my friend does not have a difficulty.
I'll just submit whatever. This order passed by the family court has actually spent itself, because that was to hand over the kids to the father till the children complete the academic year of 2024.
Then the challenge may not even be relevant.
Against which, my lords, we approached in the writ petition and they filed the contempt. Now in contempt, my lords, your lordship is well aware, your lordships intervened with the parties and the children 2 hours in the chamber, and 3 weeks custody, interim custody was given to the father in the May 2024. However, after taking custody of the children, he runs to the Supreme Court, takes a status quo order, makes use of it, keeps the children for about 8 months because of the status quo order. And now he is refusing to hand over the children back to the mother.
Situation is...
There is an order passed, please, I did not interrupt you. There is an order passed by the Supreme Court, a direction given, and I moved the court after intimating.
No, we were not.
And that is not... That is a false submission.
No, I have the WhatsApp. No, I have the WhatsApp message of my friend.
Whatever date your lordship, I have no objections. But then to say such false submissions is not required.
Today it has come up as a regular date or?
Yes, ma'am.
No, they advanced it. The regular date was 28th. Next Friday, they advanced it.
28 as per what was shown, reflecting. However, I filed an early hearing application, also a memo.
Let it be 28. I'm sorry,
28.
28. It's a regular date, next Friday. It can even be kept at 2:30.
Only
so that we don't
from 30th it was six weeks. So that is the only difficulty. I do not want your lordships to be under any kind of, because there are other pressing matters, I'm sure. That is the only thing. Whatever date your lordships,
we can close, it won't take more time to argue.
Monday or Tuesday.
I think that would be appropriate, my lord.
Could then Monday or Tuesday, unfortunately.
Lordship, can I submit, Lordship?
The council is in Delhi, also has some difficulty.
Lordship, I was appearing in this case in the Supreme Court. Now the matter was passed in the Supreme Court on 30th of January. Now they could have moved an application earlier and they've just moved it now. to have an early hearing. They have waited for a good 4 weeks themselves, 3 weeks themselves to move the applications, which they could have moved earlier. Now the matter is already on 28th, and Supreme Court, 10 months, whatever has happened, has been placed on record on the Supreme Court already.
That also
We just
has
want to
to
file
come.
it on record here.
Plus, this was uploaded
And
on.
and what they're saying, Lordship, in this case, that we took the children and then got a stay. They tried to move application of vacation of stay on several occasions, but Supreme Court did not permit because of the conduct of the party.
Lots? Because I'm okay with 23rd or 24th, Milord.
No, 23rd, 24th, I may have some difficulty. 27th,
No, Lordship, no, not 27, 25th if possible, 25th or 28th.
26th
also
started,
Sunday.
26th Thursday,
No,
Milord, next
26th.
Thursday, if that, all
26th
right.
is a
with your
holiday.
lordship.
No, 26th is a holiday. No, no.
I'm sorry.
26th or
27th.
28th, Lordship, I'll also have to come down, Lordship, if possible.
27th,
25th or
I'm okay,
28th.
but I believe my friend there had some difficulty.
25th or 28th, Lordship, if possible.
No, 25th, I have some problem.
Then
I'm sorry, we are not able to align.
28th, Lordship, may have it, we'll finish it on that day, Lordship.
24th, Milords, 24th Monday, Milord.
On Mondays,
If 28th, my lord could be kind enough to consider, it suits everybody. Afternoon or morning, anytime, my lord.
With any date, but they are not,
Respondent moved the matter.
yes, I moved the matter.
Respondent moved.
Yes.
When 8th, could my lords consider?
With your lordship's kind leave.
20, then I would request 27th, and because if my lord doesn't want to push it to the week after that. Then
27th would
may
be
I-
grateful, Milords. Grateful.
With your lordship's kind leave. Other day, I moved a memo for listing my case. Your lordship may kindly recollect that your lordships told that there is no urgency in this matter. My submission to your lordship is the Honorable Division Bench of this Honorable Court called for the DC report of the concerned district for consideration of the interim order. Therefore, the matter is bit urgent. Your lordship may kindly list this matter on any convenient day. Please, my lords, because my lords, this factory is closed since 3 years and all the employees are unemployed and the loan raised by the industrialist is also mounting to cross together. Therefore, the matter is bit urgent. Your lordship might kindly consider my prayer for memo for listing. Please, my lord. Urgency, sir. The urgency is this, my lord. On 24/12/2024, the division bench of this Honorable High Court observed that and called for the report of the DC of the district as to the factual position of the factory and also directed the petitioner. Petition is reserved with the liberty to seek further interim orders on the next date of hearing. That is the observation made by the Honorable Court. The factory is closed and the factory owner is facing lot of serious problems and heavy loans he has committed. Since 3 years, the factory is closed, my lord.
Number 18, my lord.
My lord, moving a memo, my lord, for tomorrow 2:30 p.m. for listing the matter. Yesterday that was there, but normally it will come like 77, 78, and there is an urgency, my lord. 5 years, I'm sir. My lord, and one more connected matter, almost similar to this case. Another fresh matter is also coming up tomorrow. I have asked for 2:30 p.m., my lord. So kindly take and hear both the matters together, my lord.
Serial number 18, my lord. Serial number 18 will be there. Next week, my lord. Serial number 18, my lord. Next week, my lord.
Serial number 15 and 29. Serial number 15 and 29. Serial number 15 and 29. We are please, my lords. Serial number 15 and 29, my lords. My lords, we are requesting to adjourn the matter, my lords. Senior's daughter marriage, my lords. 15 and 29. 15, 15 and 29, my lords.
Yes, 6.
29, my lords.
Serial number 53, my lord.
My lord, matter pertaining to urgency, my lord. The matter is in respect of PIL, my lord, which was filed in the year 2021. In respect of water logging, my lord, water logging. There is a water logging, my lord, it was, the interim order was earlier. My lord, because last it was posted on 4/1/2023, my lord. From 2023, it was not posted, my lord. My lord, because water were logging, my lord, due to rain, my lord. And the BBMP has taken some measures, my lord, but though they have taken measure, it was not, the problem was not completed, my lord. My lord, it's a pending matter, my lord. It's not a fresh matter.
Serial number.
Contempt, my lords. My lords, this honorable court had directed the Tehsildar to transfer the khata in the name of the complainant, my lords. However, within 10 weeks' time.
Serial number 8,
Serial
my
number
lord.
38, my lord. Seeking a short adjournment. Seeking a short adjournment, my lord. We've informed the respondent.
Fresh matter, my lords, for the appellate, my lords. Seeking for the written examination with the help of a scribe, my lords. The person is the appellate, my lords. Appellate. Appellate, my lords. Yet the date has been not announced. Okay.
My lord, serial number 38, seeking a short adjournment. We've informed the respondents in the matter.
My lord, serial number 50.
My lord, serial number 53, my lord. My lord, serial.
Yeah.
That's
Serial number 53, ma. I appear for the respondent in this matter.
53, I'm a content complainant, my lord. 53.
Short
Short
for
date.
weeks accommodation to file my response, man.
Which may be
Last
adjourned.
hearing, I filed my wakalat.
I am for complainant, my lord, in that matter.
Serial number 8, my lord.
Serial number 63, my lord. 63, madam. I undertake to file wakalat, madam. Accused 2 and 3, my lord, and 2 weeks time for filing reply.
Serial number 8, my lords. Serial number 8. I pray for a short adjournment, my lords.
With my lord's kind permission.
8. 8, my lords. Yes, my lord. Much obliged.
With my lord's kind permission, serial number 60, my lords, I appear on behalf of the accused.
I appear for the
60.
complainant, man.
My lords, the complainant and accused are mediating the issue. Mediation center. In view of the same, we request.
My lord,
Grateful,
Serial number 40, my lord.
Serial number 40. I appeal for petitioner, kindly a short accommodation.
My lord, serial number 58, I appear on behalf of respondent number 1. Short accommodation may be granted, my lord. 58, my lords. Respondent number 1. We have informed the complainant, my lords. 16. Wait for my lords.
What serial number 71, my lord?
Serial number 86, my lords, final disposal, PIL matter, senior engagement is out of station, 86. It has come for final disposal. Your lordship may kindly have it next week. Senior counsel is out of station, is in Dharwad High Court. Dharwad High Court, my lords. Senior counsel has gone to Dharwad High Court. Okay.
What serial number 71, my lord? 71, my lord. Therefore, short accommodation to remove the applicant. Therefore, short accommodation to remove the applicant. Application. There is office objection on the my lords, regarding the removal of the statue erected on the public road, my lords. Any other mention through VC, sir? Number 67.
67. Not to be placed before the bench where one of us, Honorable Mr. Justice MIR.
So contempt matter, seal number 1. Mr. A.D. Ramana.
Lordship, I appear for the complainant. It is regarding revised pension. Admittedly, the government has admitted to pay. Your Lordship will find in page 65 for the complainants.
Page 15.
Page 65.
60.
The government has also on the judgment passed by this court.
Where is direction? Direction of learner single.
The direction of the learned is on 22nd September 2023.
Page. Notice written along. 6th March.
Seal number 2. Okay, Suma K.
For complainant, my lord. This is regarding the illegal construction by the accuser number 4. As per the memo filed by them before in the writ petition, my lord. Kindly page number 11, annexure B, Your Honor. This is the memo filed by accuser number 1, 2, 3, stating that they have already taken the action against the illegal constructions of the accuser number 4. But after disposal of the writ petition, they have not taken any action.
What action to be taken?
For the demolition of the illegal construction. They have constructed 5th and 6th floor without obtaining the sanction plan.
While learned single judge in his order dated 22nd January 2024 has provided that the respondent Brother Bengaluru Mahanagar Palika will ensure that the steps pursuant to order under section 356 of the BBMP Pura Bharat Bengaluru Mahanagar Act 2020 would be taken to its logical end as per law. There is no time limit fixed by a single judge for taking such action. In that view, paragraph, the plea and the prayer of the contempt petitioner that contempt is committed is not well founded. At least at this stage, most of the contempt petition is not entertained. This contempt petition is not entertained. However, since there is an order of the court, it is provided that the necessary steps in accordance with law may be taken by the BBMP within 8 weeks from today. Failing which, comma. Failing with the respondent may be exposed to the contempt jurisdiction.
Number 3. Narendra Gowda.
So there is a direction from this honorable court to consider the application form number 57 filed by the petitioner complainant. till today.
Notice returnable on 1st April.
Number 4. The Vijay Raghava Sarthi.
Appealing for the petition. Allotment of alternative site. The price has to be determined in terms of 2010. Your Lordship get it in page 25 within 8 weeks, even after lapse of 3 months thereafter.
1st April.
Number 5. Subramania
I,
Bhatt.
I appeal for the complainant,
Madam.
Your Lordship.
Madam.
Your Lordship, Annexure A is the order passed by the learned single judge. The operative portion of the order is at page 28, wherein the Honorable Court directed the respondent to consider the representation within a period of 2 months, Your Lordship. The same is not done so far. Hence, these contempt proceedings have initiated, Your Lordship.
First April. Notice returnable on.
Oblige, Your Lordship.
Number 6.
Appearing
Mr.
for the
Ramesh
complainant
Kiara.
in this matter, my lord. My lord, Annexure C is the order passed by the, my lord, single judge of reasonable court. My lord, non-compliance of the order dated, my lord, 18 June 2024.
1st April.
Oblige.
7 is urgent. Number 8 is urgent. Number 9. It's a writ petition PL, Mr. Shivkumar N.
I appear for the government. My lord, on the last day of hearing, I had filed an affidavit. My lord, bringing to my lord's notice the action being initiated, my lord, with regard to the scam pertaining to, my lord, the fake agreements and bonds that have been yes. My lord, a further affidavit I'm filing, my lord, saying that after receipt of the Auditor General's report, my lord, proceedings under section Rule 11 of the CCA rules are being initiated, my lord.
Yeah, they're taking steps now, some
My lord?
Yes,
discipline proceedings are also initiated against 12 officers
Yes, who are held to be responsible.
for using the fake,
Yes, yes.
fake.
Yes,
stamp
for the stamp papers and fake agreements and indemnity
bonds.
bonds that are being circulated.
Lord, with regard to the action against the organization, which was actually selling these counterfeit documents, they have just said that they're just registering an FIR against them. But I think there is a requirement of special team, constitution of special
When
team, my
the-
lord.
Under the civil services rules, the
Rule 11,
disciplinary action is taken.
against the officers.
An FIR is also filed. FIR and we have respond department.
My lord, in the last page, my lord.
It's underway.
Yeah, against the association, my lord. Last page, third point.
We can't go on inquiring at every stage, and we are satisfied with this disposed of.
Obligement.
Lord, a special team may be constituted, my lord, to look into the
What
matter.
special thing? Yes. We'll keep it for orders
Obligement.
or say dispose on today's date. We'll get in the next week. Order will get in the next, yes.
Seal number 10. Dr. Surendra Kumar.
Petition, my lord.
Petition.
What is it about?
Petitioner of the villagers, my lord. It's a public road. Same has been used by the villagers for past 20 years. And Pakka was also road was formed by the government. And completion certificate also produced by the annexure C, my lord. Despite the same, respond 2 to 4 have destroyed the road and dug their trenches, unable to make use of the road by the villagers to access their land, my lord. In fact, a representation also given by the petitioners, annexure G, my lord. The photographs, annexure E and F, B, E, F, and clearly shows that there is a destroying of the road by the public. The respond number 2 to 4. Photographs, my annexure D, E, F, my lord.
What does it say?
That is regarding the destroyal of the road by the respond number 2 to 4. This is totally blockade and obstruction to make use of the road to access their my lands, my lord.
Seven petitioners right now. Seven petitioners, 7 in numbers. Who belong to the village of Kehara, Vasandra, Kubi Taluka, Tumkur district, and claim to be agriculturist as well as public spirited persons. So I have filed this petition, the nature of public interpretation. The grievance is in respect of the condition of public road, which passes from the house of Govindappa of the village to the garden land of Sinamma. In survey number 28. Big one, which is the excess of their land. It is claimed that this is the only road to approach the lands of the petitioners and to use
I appear for petitioner, your lordship.
State is there, state, you are there.
My lords,
You are the contesting. You are the
I'm for the
answering.
BBM case, my lords.
BBM.
I am for the respondent number 4, madam. We are a formal party and we have filed affidavit in this regard, madam.
Number 4. Who is number?
This is you.
See, one more aspect that is essential is
Yes, ma'am.
proper coordination between the authorities concerned.
Yes, madam.
Because you lay the road, BWSSB and the BESCOM authorities tend to come and dig it up.
Yes, madam.
Number one. Number two, the road cutting
Yes, madam.
done by private individual when they constructed a new building.
Yes, madam.
And then road being dug up by certain organizations conducting certain religious functions to erect some, what do you say, Mahadwara or something like that. See, how do you tackle these three menaces? There has to be proper coordination between the authorities concerned. Road cutting by private individuals to draw water line and other things. And there will be a lot of craters and a lot of accidents do happen because of that. And then the so-called private organization celebrating a religious festival.
My lords, regarding the interdepartmental coordination, I already addressed this in my affidavit, my lords, at page 8.
There is already a committee which is placed, which is in existence, which is headed by the Chief Secretary of Government of Karnataka, wherein regular meetings are to be held to conduct meetings between the various stakeholders, including BWSSP, BESCOM, and others, to see if there is any road cutting activities, and to ensure that there is a coordinated efforts that I've already mentioned at page 8 of my affidavit. Regarding the private persons cutting roads is a prohibited activity. And whenever any complaint is raised or it's found out, penalty is imposed on those. I can produce those documents on how much penalties has been imposed on on the next date of hearing.
You should have some regular methodology wherein private individuals who indulges in these activities, that is private individuals cutting the road for water or other purposes, or the religious organizations who cut the road to put up these the temporary structures, whatever they put up, like gate or something like that. They should be made to pay up for the perfect road repair.
Yes,
not just fill the pothole and go, which will again come out if 2 lorries ply on it.
Yes.
Or if there is a monsoon.
Lord, on that issue, the report says, my lord, that insofar as Karnataka Power Transmission Corporation and BWSSBs are concerned, even the tender shore roads will have to be cut if they have to lay rails. Only the internet lines and other new lines that are there, they are put on the side, that is on the pavement. But these two, these are the major authorities who keep on cutting the road. So now spending 18 crores per kilometer, my lord, your lordship, it's at least difficult for me to comprehend it itself in my mind, because we have something like 3,500 roads in the zone 1 itself, as per their own report. Kindly imagine the cost that we are going to incur. I am even saying, even if we did incur that cost, maybe Bangalore is a rich city, we should need some assurance that these will be good for next 25 years. Let them give an affidavit of undertaking that these are all good, all contractors which are engaged have been in the first class contractors, and for 25 years there will be no difficulty. Lord, at least some assurance to that effect.
I can have that given on the next statement.
I'm appearing for the 5th respondent, my lord, KPTCL. So far as any road cutting work which is undertaken by KPTCL, it is done by the BBMP, but the cost is borne by the KPTCL, my lord. So separately, the institution does not. Only the cost we pay the BBMP, and it is the BBMP authorities which undertake the work, my lord.
And see, again, what is noticed is when the road is cut,
Yes.
when the repair work is done, that repair work is like a small patchwork.
Even for the
originality is not restored. It is not done properly.
Lord, on that issue, my lord, there's already an order by this court that mechanized system should be used. And it was in that related one private respondent was also added. Though, my lord, their complaint, my lord, I am not speaking for them. Their complaint is they're not paid and that they are not using the motorized and mechanized system. Again, they're gone back to the same giving contractor, put jelly and mud and close it, which will not stay even for 24 hours.
That mechanized system was not viable, my lords, because it had a very small carriage space. And for even a single pothole could not be filled in one trip. There was many other issues which I'm not fully aware of.
We are not insisting on a
Neither am I
particular
saying.
system. The thing is, if once the road is laid, which is supposed to have a life of around 25 years, 25 years, so how many years?
A large number of years.
No, now as per
the tender shore roads which have been laid, first road which was laid in Bangalore is the St. Mark's Road, my lords. It's almost 10 years as of now. Not a single pothole has been developed and not one cutting of such roads. We have developed 14 tender shore roads so far. Not one of those roads has been cut so far because all the amenities are shifted on the footpaths. The road is entirely carriageway. I can get the engineers to talk to me and inform me about how many years is the sustainability of this road. I can file that through an affidavit on next day.
Unauthorized cutting also you need to tackle.
I will do that.
How we are going to do it,
Yes,
you'll have to say.
Any day, my lord.
2015 petition.
My lord?
Very old petition.
Lord, it is old petition, Lord, as I said.
There has been
We are
development
all
every time.
doing some social service in this, and not that I have any personal interest, but I can say from my personal experience in the past, at least 5-10 years since the petition is there, our roads are little semblance. And this court on 31/7/2019 has held that it is a fundamental right of each citizen to have our motorable roads. And only after this court took them all to task that we have come to this level. Lord, and if we are going to just leave it, Lord, I would say that it would go back. It can be taken once in 3 months. I'm not
For filing
insisting.
of my affidavit of 15 days period.
It can be given more time also, Lord. I'm not insisting that to waste the time of the court.
Any day, ma'am.
BBMP requested for time to file further affidavit. 2 weeks time is granted, stand over to 21st March.
Yes, ma'am. 20%.
Seal number 12, Mr. Samit Sharma.
I appear for the response.
Petitioner.
Before my learned friend starts, my lord, may seek for a short adjournment, my lord. The reason is this, my lord, I've just received the instructions. I'll have to place it on record, my lord.
This is the PIL pertaining to examiners and experts under the Indian evidence.
Please, please. Yes, it's important. Please, so when shall we take up? Lord, 2 weeks, my lord. 2 weeks. March.
Please.
Grateful. I'm grateful.
Please.
See, probably you can think of having a panel of qualified persons
Please.
to do this particular job, number one. Number two, if you can think of having a mechanism where the person, I mean, whoever has it referred to them, the private individual will not know to whom it has gone to.
Please.
Just like an examination paper.
It should not be known. my lord.
It should not be known.
not be
The person analyzing that particular thing who
Please.
gives a report,
Please,
after giving the report, they may know that.
please.
But why, before giving the report, that person should not know whose work he is doing.
Lord, as of now, my lord, the instructions what I've received orally is that, my lord, the person who has given it will not know who is the person who is examining it.
Exactly.
Please, my lord. Even in the case of forensic, my lord, where the forensic experts, my lord, they would not be knowing to which case they would be doing and who has referred it.
Correct.
That
No,
mechanism.
This aspect has to be kept in mind.
Please, madam,
because you'll require any number of people to do this work now.
Please, please. I understand. I understand what is falling from the court. Please, please.
Yes.
Great.
That becomes important.
I'm grateful.
Great.
Seal number 13, say green bench matter. Mr. Vinayak Avi.
Lord, I appear for the petitioner. The petitioner is a partnership company, my lord, which has applied for grant of mining lease for ornamental store. That application has been rejected by the authorities. That's under challenge, my lord. Lord, the petitioner is a partnership firm, my lord. The reason is one of the partner who he was also a partner in another partnership firm. My lord, Annexure A, typed page 26 may be kindly seen. My lord. The authorities have considered, my lord, various applications together. In that, my lord, page 29.
Yes.
The second paragraph, serial number 1. Measures Hamsa and Company, store quarrying license application number so and so dated 5/12/2012. Sri G. Anand Kumar, partner of Hamsa and Company, attended the inquiry on so and so date. He belongs to the scheduled caste category, partner in Measures Maina and Company. They have 3 leases of green decorative stone mining in a total area of 11 acres, 20 acres at so-and-so villages, Chikmagaluru Taluk. And they own granite cutting and polishing unit as on the date of applying for quarrying lease. This is the observation, my lord. Then, my lord, the rejection part is at page 33. Measures page 33, my lord. Serial number 1. Measures Hamsa and Company Stone Quarry application number so-and-so dated 5/12/2012. Shri Anand G. Kumar, partner of so-and-so, attended the inquiry on 16/10/2023. He belongs to scheduled caste category, partner in Maina and Company. They have 3 leases of green decorative stone mining in a total area of 11 acres, 20 acres in so-and-so village, Chikmagaluru district. They own granite cutting and polishing unit. As on the date of applying for quarrying lease, though the application submitted by persons association belonging to the scheduled caste schedule category under Rule 12(1)(a), even if the applicant belongs to scheduled caste, for the consideration of the provisions of this rule is not applicable to the application submitted in the name of partnership firm. My lord, this I am not, my lord, I am not aggrieved. Then, my lord, as per Rule 15(1) and 15(3) of the KMMC rules 1994, it exceeds the area of 10 acres, hence the application is liable to be rejected. My lord, so far as the petitioner partnership is concerned, my lord, it does not have any lease, my lord, in other quarries. The another partnership firm, my lord, which is Maina and Company, that owns, my lord, 11 acres, 11 acres, 20 guntas of land, my lord. It has the leasehold rights. On this ground, it is rejected, my lord. We do not have any mining lease in any other area. My lord, 15, Rule 15, my lord, it does not say. It says only regarding the applicant. And also, my lord, this G. Anand Kumar, though he represents the company, my lord, as a representative, he retired from this partnership, my lord, in the year 2015 itself. And my lord, I have produced that document also.
The Rule 12, capital 12(a)(1), what is that rule?
My lord, as per 12(a)(1), my lord, that's a repealed rule.
So you applied under the category of scheduled reserved category. You applied under
under reserved category, that is one ground, my lord.
So they are saying that it is a partnership firm.
Please, my lord. Therefore, that may not be applicable. Then, my lord, the other categories are there. General categories are there. Now, my lord, what they say is, my lord, page 37 may be kindly seen, my lord. Value 1(a), my lord, may not be applicable to me because this Anand Kumar, he belongs to a scheduled caste since it is in the name of the partnership firm. They say reservation is not applicable. Even then, my lord, there are other, in the general category, I am eligible. And nobody, my lord, there is no overlapping. Somebody else is not claiming this land. Therefore, land is also available. Rule 12, my lord, priorities. Selection from among the applicants for grant of quarrying lease under this chapter shall be made in the following order of preference. A corporation or undertaking owned, controlled by the state government or central government. Persons who have already established 100% export oriented. My lord, I do not fall under this category. Persons who have already established small scale industrial unit for cutting and polishing of granites in the state. Then, my lord, 4, persons who hold a valid license for establishment of granite cutting and polishing unit within the state for the purpose of 100% export, and persons who hold a permanent registration certificate for establishment of small scale industry unit in the state. I fall under, my lord, this category. And, my lord, in clause 2, in case of applicants falling under clause 4 of this 12 who require to specified mineral for their proposed industry, they shall set up industry in accordance with within a period of 24 months. So I have 2 years time to establish the industry.
What is yours?
My lord, I'll take notice and I'll, coming up for the first time today, my lord.
And also, my lord, if that Maina and companies, it has to be considered together. They have, my lord, the industrial, my lord, unit. Your lordship may kindly see rule 15. 15 says, my lord, one or more quarrying leases or license covering a total area of more than 50 acres for the purpose of mineral-based industries and 10 acres in the case of other purposes. So far as this 10 acres is concerned, Lord, if I do not have do not take it for industrial purpose. They say you in another partnership firm, you have more than 10 acres. But that partnership firm, if taken together, they have an industrial unit also. In that case also, my lord, I have to be considered under this rule. Either way, my lord. Please.
28th March.
Great.
Sunil Kumar.
My lord, I represent, my lord, the counsel for the petitioner. So it's a public interest litigation, my lord. Basically, there are some mining activities and, my lord, illegal transport activities, my lord, in a place where there are, my lord, it abuts to forest area, and, my lord, there is a deep vegetation of, my lord, huge number of, my lord, valuable trees, particularly sandalwood trees and, my lord, other forest trees. Repeated representations have been made requesting the government, my lord, not to issue permits unless and until, my lord, afforestation is made. In spite of that, my lord, they are issuing, my lord, permits. My lord, I have produced the pictures and also, my lord, various representations, including, my lord, the reports raised by none other than the forest officers, which confirms, my lord, that the area under question, my lord, has dense vegetation in it. Therefore, my lord, the notices may have to be ordered in the meanwhile, my lord, till they appear, my lord, let there not be, my lord, any activity that will, my lord, take away the existing forest, my lord. That's the, my lord, minimal prayer. If my lord should kindly have, my lord, annexure D, page number 51. It is the report drawn by none other than the forest officials. Lord, apprising the conservatory about, my lord, the existing forest. Page number 40, my lord. And the English translation, my lord, should kindly find on page number 41. There was, my lord, initially an inventory drawn in the presence of all the villagers and the forest officials. My lord, the existence of forest and deep vegetation with valuable trees was confirmed. Secondly, my lord, the zonal officer raises a request to the conservator of forest, my lord, updating the existence of forest and, my lord, the unlawful mining activities. Despite all these things, my lord, the mining department would issue transport permits to, my lord, to enter into the area and, my lord, scoop out the material and port it away. By cutting the trees, my lord, which are existing there, my lord, that is the concern.
My lord, let the railways be made a party, my lord. Railways.
Railway.
Yes.
We shall
because-
implement the railways also, my lord.
Why railway?
My lord, paragraph 9, it is for construction of a railway sliding and repair of a railway lane. So railways may be made a party, my lord. In the meanwhile, I'll take notice and I will apprise my lords.
In the meanwhile, my learned friend, my lord, Nilofer madam, may also, my lord, send them, my lord, suitable message to not to, my lord, continue the activities of, my lord, granting permits and trying to port away, my lord, the material.
In case, in course of the preliminary hearing of this public interest petition, it was suggested by learned additional government advocates that the railways would be necessary party, full stop. In response to this, learned senior educational so and so prayed for permitting to add railways through its competent authority as party respondent. Full stop. Permission is granted because status will be amended by adding railways as party respondent. Full stop. After the amendment is carried out, notice to the respondents returnable on second April.
Great. I am greatly obliged.
Lord, I think even this the purchasers, my lord.
Yes, Sai Balaji
Balaji
Sponge
Sponge,
Iron
yes.
India Private Limited.
Yes.
Has it been conferred some right on that property?
No, they have been they have purchased the iron ore. They have not been made a party.
Lordship, one request, Lordship, my colleague name is showing the, along with Sunil Kumar as Praveen Kumar NK name will be shown in the cause list, Lordship.
You file wakalat now.
I am filed the, I'm a on record counsel, Lordship.
Shown by the
15.
list.
15 is urgent, number
Interim
16.
prayer granted, Lordship. Is interim prayer granted, Lordship?
Interim prayer is refused.
Great.
Number 16, the writ appeal, Mr. Gaurav GK.
For the appellant corporation. There's an application seeking for condemnation of delay, my lord, of 172 days.
Coming up for the first time,
Yes.
Please, no,
notice returnable on.
to respond number 2, my lord. Respond number 1, my lord.
Notice for R1, my lord.
All.
Respond number 2 is the private response.
Respondents returnable on. 25th March, Loan and Additional Government Mr. Harish accepts notice on behalf of Respond 1 State of Karnataka. Post of Respond 2 shall be served with the notice.
Please, great.
Number 17, the state appeals.
Notice, will issue notice.
Please.
1st April. Return.
This is number 18. Mr.
18 is adjourned.
Number 19.
Hmm.
Mr. Mahesh M.
In this matter. Plus, the writ appeal is filed by the victim in this matter. Now, if I may be allowed to briefly go over the facts. On 21/6.
Delay to be con, yet to be condoned.
My lords?
Delay is there or not?
Yes, my lords, but there is a reason for it.
19.
We were not made a party to the writ petition, even though we are the victims in the matter. In 2021/6, the accused came and stole a golden chain from the accused, from the appellant herein, who's 80 years old.
Number 1 of 24.
Yes, my
which
lords,
is
the
grant of leave to appeal, IA number 2 of 24, which is condoning delay of 19 days and in writ appeal.
so the writ appeal,
Returnable on
my lords, if
7th,
I may continue.
7th April.
So they had stolen that property and we had filed a complaint on 14, and on 14/9, the accused was caught under crime 172. And they had made a statement that they had pledged the stolen goods, the stolen chain to the respondent number 1, who is a pawnee. Now the respondent number, and once we realized that, we were called by the police to identify whether that chain was indeed ours, and it was confirmed that it was the appellant's chain. And when we went before the magistrate to seek the release of the chain under 451 and 457 of CRPC, we came to realize a writ petition had been filed by the respondent number 1 without making the appellant a party, who is the one who would file the complaint, who is confirmed to be the owner of the chain. And on 19/9, it was passed by the Honorable Single Bench that the chain would be released and restored to the respondent number 1 without hearing the appellant, who is the victim. Further, it is also known that, my lords, in your own matter in the previous, had also held that when the pawnee had approached the court trying to quash the police who had sent a notice seeking the production of the chain for investigation. My lords held that it is just necessary that the police may investigate and there is no hindrance caused to the pawnee. But here in the writ petition, the court has held the coordinate bench's judgment, wherein it was held that the stolen item may be released without hearing the appellant, has also held the same and released this in this impugned order without making us a party. Hence, we filed the application for IA number 1, seeking the court's leave in order for us to proceed with this appeal, my lords. IA number 1 may be allowed, and on IA number 2, we may be allowed to serve notice to R1. My lords, one further thing. The Supreme Court in 2024 has also held that under writ court, the court does not have jurisdiction to release a stolen good in which is part of a criminal proceeding, which has been done in this particular matter, which is why we've sought this appeal. We may be permitted to file, to issue notice to the respondent number 1. If possible, by hand, we'll only serve the notice.
At hand, not service by hand delivery is permitted.
And the respondent number 1 may be directed not to release the stolen product to the accused, my lords.
There's a condition already, my lord. There's a condition already. I take notice for R2 and R3.
Bill number 20, Mr. Swarup, yes.
Appearing for the first respondent.
Delay of 3 days, we shall be condoned.
Please.
IA number.
Grateful, madam.
2 of 24. Having heard learned counsel for the parties. Delay of 3 days is condoned as sufficient cause is made out. Application is allowed.
Grateful, madam. In page 15.
Not represented. Not represented. You are for whom?
For KPTCL, my lord. The
Let's
first
go.
respondent.
Yes.
They are the affected party.
Let's go.
So KPTC.
KPTCL.
Not
Bestcom is the second respondent, but
Then
I've
notice.
not been.
No, she's appearing for KPTCL and KPTCL is the contesting respondent, not Bestcom.
Then
I am an employee of Bestcom. I applied to KPTCL for recruitment. KPTCL has not given me recruitment.
that is right, but Bestcom will have to be served at least formality, even for formality.
No, there was an interim order throughout the petition in my favor. That petition, that order may be.
We'll keep it, serve them the hand delivery notice returnable on 3rd of March.
But it's a issue of employment. If that post goes, then it becomes infructuous. That's the concern. Since 2018, the interim order has been in my favor.
How can we pass when there is a delay?
Lord, they
Well,
don't
the
qualify
contesting-
Lord, what the recruitment notification specifically sets out the physical disabilities, my lord. That the petition appellant herein does not qualify. On this ground, his application was not considered, my lord.
We will submit arguments on merits. It is KPTCL which has to keep the post open. They are present before this honorable court. They will also acknowledge that during the pendency of the petition, the interim order was operating in my favor since 2018. Now with this delay, something is filled up, then
The reason being, my lord, my instructions are that he does not qualify itself. So that is why
That
the
evidence.
question of reserving that post would not apply. I'll take instructions on that direction as well. Because before the learned single judge, I did not appear. My lord, I'll take instructions.
27th.
until then not to do anything.
She is taking instruction. That means that you will stay your hand.
Very good.
Don't do
That should be
anything.
enough.
Don't precipitate the thing.
My lord, it is filled up. This notification is of the year 2016.
No, that is incorrect because until now, that order was there. They could not have filled it up. And there has been no recruitment notification thereafter.
So then there will be the question of you are apprehending appointment.
Appointment. That's the concern.
Anyone select?
There's no one else selected apart from me.
Okay.
Let them just not do anything. There was an order in my favor, that's all.
27 notice, 27 by a notice by hand delivery is permitted. Will have a learned record Mr. and so web service on access notice on behalf of
Respondent number 1, my lord.
1.
One.
This one too shall be served.
Grateful. Will do.
Obliged.
Take instructions on that.
Please, I take instructions.
This is number 21, so Nishant AV.
Here also notice will be required. Notice returnable on 20th March.
Let's delay may kindly be conducted. Delay, there's a delay of 50 days.
In that only notice.
Please.
Number
Please.
22.
My lords, I appear for the appellant in this matter, my lords.
Yes.
The appellant, my lords, is the registrar of the DRT, the Debts Recovery Tribunal, my lords. The respondents, my lords, were borrowers from the bank. They had filed a petition before the DRT seeking a stay of the auction. The auction did not take place, my lords. Their petition became infructuous before the DRT. They made an application for the refund of the court fees paid to the DRT, my lords. The DRT has rightly refused it. They file a writ petition against that order, my lords, and the learned single judge has permitted refund of the court fees by the DRT. My lords, my first submission to your lordships is that DRT, my lords, is functioning under the Debts Recovery Tribunal Act and also has jurisdiction over matters arising under the SARFAESI Act. My lords, under the DRT Act,
Okay, for the caveat to respond, private respond.
my
Caveat to
lords, I have not yet completed my submissions, my lords.
Yes, please.
My lords, the DRT has jurisdiction over two types of matters, my lords. One arising under the Debts Recovery Tribunal Act and one arising under the SARFAESI Act. This proceeding before your lordships was under the SARFAESI Act, where they challenged the auction. My lords, the Debts Recovery Tribunal matters are for banks to recover debts. Over there, my lords, there is a specific provision which permits refund of the court fee based on the stage of the proceeding. Under matters arising under the SARFAESI Act, my lords, there is no provision under any law applicable where there is refund of court fee. Therefore, my lords, the DRT rightly rejected the application of the respondent caveators that court fee cannot be refunded, my lords. The learned single judge, my lords, relies on a number of decisions arising under the Karnataka Court Fees Act, my lords, where there is a specific provision permitting refund of court fees when the matter is settled. And on that basis, my lords, has directed the DRT to refund the court fee to this particular respondent, my lords. My humble submission to your lordships is this order, the impugned order, my lords, is wholly contrary to any existing provision of law, my lords. In spite of placing all this before the learned single judge relies largely on the Court Fees Act to order the refund of court fee, my lords. My lords, my difficulty is if the DRT is asked to refund the court fee, first of all, there is no provision. Secondly, my lords, it has serious financial implications for DRTs across the country. When the Act does not provide tribunals, my lords, your lordships are aware, are largely funded by the court fees that they collect. The legislature in its wisdom has not provided any refund for SARFAESI Act proceedings, unlike in the DRT Act proceedings where there is refund that has been provided.
Notice written along.
If I may make one submission, I go down. If I may make one submission on the very aspect of maintainability of the appeal itself. My respectful submission before your lordship is this. The proceedings before the learned single judge was one under Article 227 of the Constitution. Therefore, a 227 order in my respectful submission is not appealable before this honorable court.
Tamanna.
In fact, I'm grateful that your lordship has brought up the aspect of tamanna. My respectful submission is there are two judgments of this honorable court. One by a 5-judge bench in Gurushant Pattedar, which was affirmed in Tamanna, which was a 7-judge bench. My respectful submission is, although these judgments pertain only to those orders that are passed by civil courts. And when civil courts pass an order and it's taken up before the learned single judge, then that has been held by your lordships as not being appealable before this honorable court. My respectful submission is, after Tamanna, in fact, just before Tamanna, immediately after Gurushant Pattedar was rendered, in fact, I'll just pass on a couple of memos for lordship's kind consideration. Yes.
My lords, kindly see the writ petition, my lords. It's filed under Article 226. There is not even a formal mention of 227. Therefore, the maintainability objection cannot be taken, my lords. This is
My
an order under Article 226. Kindly see page 46, my lords, the writ petition.
My respectful submission is, insofar as the rubric or the nomenclature of the writ petition is concerned, the Honorable Supreme Court in Radhesham and in other judgments have held that mere mentioning or non-mentioning of a provision is not fatal, is not determinative. Now, your lordships, I've just passed on a memo before your lordships. I'll just place before your lordship one predicament that I'm dealing with. The predicament is this. Following the judgments of Tamanna and Gurushan Pattedar, there is a whole line of citations which all rendered by division benches of this honorable court, which espouse the law in both ways. It enunciates the law in both ways. One set of citations, I'll just pass on. Which one? No, the other one. There are two lines of case law before this honorable court ever since Tamanna was rendered. One set of citations says that all those orders that were passed by the learned single judge qua statutory tribunals and authorities are appealable. And against myself, I have to place it before a lordship as a matter of transparency. There is another line of case law which goes on to say that no, it is not appealable, and the other which says it is appealable. I've just passed on that memo. My respectful submission is, lordship may kindly take volume 1 of the memo that I've just passed on. I just point out, in fact,
here the maintainability part also.
please, my only respectful submission is this may require some detailed consideration, because if your lordship were to just take a look at this memo, I'll just open the index of the memo, nothing more.
Lord learned advocate Miss Mayan.
My lords, I'm also praying for a stay of the order, my lords, because there's an order of refund.
I will undertake not to precipitate. I have no difficulty in making that undertaking. I'll undertake.
Written along 27th March.
My lords, in addition, I may be permitted to serve the counsel for the bank who appeared before the learned single judge, my lords. Respondent number 2 is the bank.
Keeping the aspect of maintainability of petition
please
open to be agitated by the parties at the time of hearings. Learned advocate appearing for respondent upon service of copy of the appeal in advance fairly stated that the respondent will not precipitate
please
the subject matter. 1 and 2.
Please, if I may just request your lordship to just take a look at this memo, not on merits. I just want to show to your lordship the divergence of views of this honorable court. Multiple division benches of this honorable court have interpreted it one way or the other. So therefore, my respectful submission is this matter may require some consideration, because there are multiple division benches which have taken the view one way or the other.
What is the discrepancy according to?
Sorry, your lordship.
What is the discrepancy in the approach?
I would not call it a discrepancy. I would just
inconsistent.
Please. Lordship may please see my memo for a moment. Memo volume 2. Lordship may kindly see memo volume 2. In my index itself, from page number 2, I have mentioned those decisions which hold that intra-court appeal against an order passed by the learned single judge while examining.
Where you are reading?
Lordship may kindly take the memo of citations volume 2. Volume 2, which I just passed on. Page number 2, lordship kindly comes to. Page number 2.
Page number 2.
Please. I have denoted it as part A. Part A. Decision. Part A, page number 2. Inked page number 2. Please. Decisions holding that the intra-court appeal against an order passed by the learned single judge while examining orders or decisions rendered by tribunals and quasi-judicial authorities is not maintainable. There is a whole line of case law which we could lay our hands on. There are 13 such judgments which say, for example, when matters arise, let's say, from the labor court or the industrial tribunal or any tribunals for that matter, those appeals are not maintainable. Whereas part B, in fact, if a lordship were to see inked page number 5, these are also, again, judgments rendered by the division bench of this honorable court, which say that in similar circumstances, an appeal is maintainable. So therefore, and in fact, the latest judgment in this part comes only last week, passed by a coordinate bench of this honorable court, which takes the view that the appeal is maintainable. So therefore, my respectful submission is, of course, Gurushant Pattedar and Tamanna have taken the view only qua orders arising from the civil court.
Probably both are absolute views. Both are partially correct. The true law, whether it is 226 jurisdiction or 227 jurisdiction, is what is the nature of relief and in what
Please.
manner granted by on a single judge.
Definitely.
Whether the relief granted or observations made in the judgment
Please.
travels beyond the realm of 227, original challenge or not, that is the real acid test.
In fact, since your lordship has now fixed the matter for 27th March, I will take your lordships through all of these
So
judgments.
neither the nomenclature nor the prayer
Yes,
will
definitely.
determine finally. It is the ultimate order which may be passed by
Definitely.
on a single judge of the court.
Please.
Whether it travels beyond the four corners of 227
Please.
and exceeds to
220. I bow down to that proposition that it is when under both 226 and 227, then I understand we can come before your lordship. But these are citations which are.
there may be matters you are right, is absolutely outrightly not maintainable.
Yes, insofar as 227 is concerned, my respectful submission is, these are all judgments that are cited before your lordship, which restrict the reasoning insofar as 227 is concerned. They say, if a matter falls in the realm of 227, Part B says appeal is maintainable, whereas Part A says it is not maintainable. So there is some divergence of views is my respectful submission.
We'll crash it. We'll
Please.
consider in this matter on. Yes.
Please.
Very well. I'm grateful, my lord.
When it is kept? 27.
In fact, I'll serve these copies on them. They are not here. I'll serve it on them in advance. They can also assist your lordship. I'm grateful.
Grateful.
Bill number 23, the state appeal.
State appeal, my lord, there's delay, my lord.
Delay.
Delay is done.
So notice on 26th March.
Bill number 24, to Sunil Kumar H.
Again delay, 24th March.
One submission, my lord.
Yeah.
So this is an order which is challenged against the order passed by learned single judge, which has arisen out of the Senior Citizens Act, my lord. But now the petitioner herein is the mother, my lord. Petitioner
Arising out of citizenship.
Senior Citizenship Act.
Senior citizen.
My lord, now the petitioner, the appellant herein before the lordship is the mother. My lord. I'm staying in the premises from past 20 years. Now my son, what he has done is he has sold the property to a third party and they're trying to dispose me from the property. I'm only seeking lordship's indulgence to maintain status quo, my lord, because now if I am dispossessed from the property, my lord, in which I'm staying from past 20 years, so that will again give rise to new cause of action.
We don't assume jurisdiction over the main matter unless delay is gone down. That's the difficulty. You can have earlier instead of 24th. If there is
Any date,
urgency.
lordship's convenience.
No, 14th of March.
Please, ma'am.
14th is holiday. No, not holiday. 14th of March. Service
Please.
by hand delivery is for it.
Please, ma'am. Great.
Bill number 25, Sanjay Krishnavi.
26, it goes together.
Just for the brief narration, my lord. On 25/8/2011, an application under the PTCL Act for resumption of land is made. On 2/9/2014, Assistant Commissioner passes an order of resumption. On 24/9/2015, the grantees or the LRs of the grantees, they make an application for permission to sell the property on 24/9/2015. There was a condition that they should have alternate land, they should purchase alternate land, etc. All those things were complied with. alternate land was bought by them. Thereafter, on 9/10/2015, permission was granted under 4(2) of the Act. The present appellant purchased the property on 14/10/2015. An appeal is filed on 7/2/2016. After 1.5 years of the order, appeal is filed. In between, permission is granted. Present appellant has purchased. Now, my lord, on several counts, the learned single judge finds all these things are wrong, etc. But ultimately, the order, your lordship may kindly see, without reference to this aspect of the matter for which appellant cannot be blamed. Kindly see page 117, ink page 117. That would be typed page 85 of the learned single judge's order. As a further consequence, the Deputy Commissioner is directed to take immediate steps to evict H.R. Suresh, that is the present appellant, from the lands in question, put A.J. James, contesting respondent, Ansi James, and also the wife and children of Govindaraju in possession of land bearing survey number so-and-so, Jala Hobli, Bangalore North, so-and-so. Deputy Commissioner shall file an affidavit of compliance by 24/2. What the learned single judge, apart from that, does is, you having purchased and taken possession without knowing, without due diligence, whether dispossession has taken place in accordance with the Rule 13, etc., a cost of 5 lakhs is levied on. If the Assistant Commissioner's order of resumption is wrong, for a moment, even assuming that, I was a person who came in after approaching the government, after getting the permission. Thereafter, I purchased the property for a valuable consideration under a sale deed. Appeal against the Assistant Commissioner's order is filed about 4 months after my sale deed, 1.5 to 2 years after the original order of the Assistant Commissioner. And I had the benefit of the interim order in the writ petition. Of course, my lord, the learned single judge appears to have been moved by the fact that all these things are complications created only by the grantees and the government in granting the permission, of which the present respondent James has become a victim. Several such things have been, appears to have been moved. But ultimately, as far as I am concerned, I was a purchaser of property after the order, after taking the permission. And in fact, page 151, your lordship may kindly see, in the writ petition, I had made an alternate prayer. In case the court finds that all those proceedings were wrong or anything, as a third party bona fide purchaser, I was to be returned at least with the consideration amount that I had paid. And page 115, learned single judge says, it is the government's mistake in granting the permission which has resulted in all these complications. Page 115 may kindly be seen. Ultimately, learned single judge finds, para 125, that the grant of permission under 4.2 was without application of mind, without going into all this thing which has in effect created all these complications is the finding.
My lord, I respectfully submit. I am
Ask them whether they have the competency certificate to address the problem. Not of that. So we can't hear.
My lord,
You are not
I
competent to
may be given a few
Can't
days
address
to
unless you have the-
comply with the party in person
You can't
regulation. I
address
am the
unless you-
caveat, my lord.
Kindly listen, you can't address the court unless you have the competency certificate. And we are not bound to listen to you unless you have the competency certificate.
I gave a representation to the registrar judicial to do it. Yesterday only I came to know about this, and then they couldn't manage it because without the writ appeal numbers, I can't file. Along with my caveat, I filed the Form A and B to give me advance permission to come before this. I have complied that all while, and I am meticulous in that. I'm a retired government official, and I am very, obedient to the rules of the court. And I am the person who had filed all these documents meticulously and carefully. And my farmhouse was demolished by the petitioner by taking, when I was not there, by this behind my back, all this was done.
Yes, applied. But it is applied. Yes. So what order was operating during the pendency?
Now, my lord, your lordship may kindly stay the learned single judge's order here. He has given a positive direction to dispossess me.
What was the order operating during the pendency of the?
That is the stay of dispossession was the order.
My lord, I've been informed, my lord, that possession has been delivered, my lord. I will take an official confirmation, my lord. In pursuance of the order of the learned single judge, I'm informed that on 17th February, possession has been delivered to the respondents. I'll seek a confirmation on that, my lord. If possession is not delivered, my
There
lord,
cannot
then
be a
stay of-
delivery of possession without notice to me. That is what the learned single judge finds as a fault.
Writ appeal number 223 of 25. Referred by the original petitioner, this writ appeal is directed against judgment in order of learned single judge dated 24th January 2025, whereby the writ petition came to be dismissed. What was prayed in the petition was to set aside, where is the prayer? Order dated Woman order dated 22/5/23 passed by the Deputy Commissioner, responded to herein. Whereby the land purchased by the petitioner appellant came to be restored in favor of the private respondents herein. The further prayer was to direct respondent for authority to restore the entries in the revenue record in favor of the petitioner. Full stop. Original respondents appeared. What is your good name?
A.J. James, my lord.
Ask the name.
A.J. James, my lord. I'm respondent 5 in this.
in course of the hearing of the appeal, respondent 5, claiming to be one Mr. A.J. James, appeared and wanted to make submissions. When inquired whether paid part in person has obtained competence certificate under the High Court rules to appear in part in person, in capacity of part in person, and whether the competency certificate is issued. It transpired that the process that the application is made, but the committee has not taken a decision. Full stop. In this view, in order to enable respondent number 5 and any other respondents to appear either as part in person with competency certificate or through learned advocate, or by engaging learned advocate, the appeal is adjourned to 25th of March, full stop. In order, it was submitted by learned senior advocate Mr. So-and-so for the appellant that during the pendency of the petition throughout, the interim order was operative in favor of the appellant petitioner, full stop. In that view, and in view that the reversible situation does not arise for the appellant, it is directed that the parties shall maintain status quo with regard to subject matter land, and the same shall not be encumbered, transferred, or alienated in any manner whatsoever.
The next one is the same. There were 3 petitions, therefore 3 appeals filed.
Same order.
Same. I may be permitted to.
Sir, yes. It will be available. Make submissions on this.
Please.
The appointment order does not is without prejudice to rights and contents of the party to make submissions.
This is number 27, state appeal.
Is state appeal, my lord. 27 is state appeal, my lord. Delay is there, my lord. One submission I would like to make, my lord. There is a contempt petition that has been filed, my lord. Lordship has passed an order on 10th February 2025 and posted the matter on 28th February, my lord, to enable us to carry out the compliance. Our grievance is very limited, my lord. It is a case of compassionate appointment, my lord, where the writ petitioner's father passed away. He was working in as a Gram Panchayat, a temporary employee. Now, my lord, the learned single judge has directed us to consider the representation, treating him to be an employee of a municipal council, my lord. Before the Gram Panchayat could be upgraded to municipal council, my lord, he passed away. No difficulty in considering the representation for compassionate grounds, my lord. But there is a rider, my lord, which says that he should be treated as deemed to be an employee of municipal council, my lord. That is the difficulty, my lord. Contempt is scheduled on 28th February, my lord. Lordship has passed an order that there should be an enabling orders of this court in writ appeal before the next date of hearing.
Delay is to be condoned or not?
Condoned, my lord. Delayed has to be condoned. I have served an advance copy on the council appearing on the writ petition.
Anybody is appearing?
Pardon, my lord?
Anybody is? Notice not, that is what we have. So when the contempt is coming back?
Contempt is coming up on 28th, my lord. 28th February, my lord, yes. I have served them an advance copy on the council appearing in writ petition because there was a delay.
It was stated that the contempt petition arising out of the very judgment and order is to be listed on 28th February. There shall be notice in this appeal, returnable on the same day. It was stated by learned edition government advocates, Mr. Harish, that a copy of writ appeal is already
I have an acknowledgement
in advance.
Please.
To learned advocate for the respondent.
Can I request for 27th, my lord, because the contempt lordship has said, directed the director to appear before the court in the event of non-compliance, my lord.
27th.
Please, my lord.
Remind us on that.
Please, my
We also inform the others.
Yes, my lord.
Whom you have given the copy.
I will inform, my lord.
This is number 28.
My lords, I
Naveen
appeal
Chandra
for the appellant. My lords, here my lords may see there was an arbitration award. There's an arbitral award between the parties. The arbitral award, kindly my lords may see at page 427. 427, the operative portion, my lords, the awards, the directions are at the bottom. Direction number 2 is respondents, sorry, 427, my lords.
427.
427, ink page 427.
It starts at which page?
The award starts at page 348, but the final operative directions are at page 427. 427, number 2, respondent directed to execute sale deeds and get them registered in favor of claimants in respect of 19 sites described at number 1 to 19, for which sale deeds have already been executed by BDA. Number 3, respondents are directed to execute and register sale deeds in favor of claimant in respect of 2 awarded sites so-and-so, described at so-and-so, within 2 months from the date of BDA executing sale deeds. Now, my lords, these 2 sites, the award says only when I get them allotted, executed in my favor from BDA, I have to thereafter within 2 months give it. Now, as respect in this arbitral award, I have filed an appeal under section 34 that is pending. And my lords, the respondent number 1 files a writ petition against BDA and me.
So you have filed 37.
I have filed 34 proceedings. 34. 34 proceedings.
Set aside the.
To set it aside. That matter is pending. The final order in that is still not out. While it is pending, the respondent who has got this award files a writ petition impleading BDA, and in fact, learned single judge, my lords, at page 21, passes an order. BDA should allot the sites in my favor, those 2 sites. My lords, that is subject matter of arbitration.
BDA was party to the arbitration?
No, BDA is not at all a party.
Where is the order of learned?
My lords, learned single judge order is at page 21. Kindly see who are made parties to this learned, to the writ petition, page 21. Parties, first respondent BDA is made. BDA is not at all a party to the arbitration. 21 is the arbitration, my lords may see. Arbitral award starts at page 348. The parties are the company and the 2 individuals. Because the arbitral award is between us for sale of property. BDA is nowhere concerned. Thereafter, the land has been made into sites, which I said I will allot to you. If, and which is what I'm challenging. The learned single judge, if my lords would see, goes on at ink page 25, para 9. They pass a direction in para 10. If I can read out para 10 or para 9. There is an award in favor of petitioner as noted above, and the same is also subject matter of appeal pending consideration. Direction sought for by the petitioner against respondent number 1 BDA is only to execute deed of sale in respect of aforesaid 2 sites in favor of R2, which even executed would not create any right, title and interest in favor of petitioner in any manner whatsoever until disposal of the appeal, which is stated to have been pending consideration. In view of the aforesaid fact situation of the matter and in view of submission made by learned counsel for R1 BDA, BDA is hereby directed to issue an intimation to R2 specifying, that is to me, specifying the date on which it would execute deed of sale in her favor and shall execute the deed of sale.
Now, was learned single judge aware about the 34 proceedings?
Yes, in fact, that is what in para 9 it says that the appeal is pending.
That we have noticed,
Yes.
but appeal is not referred to anywhere.
No,
Anyway,
appeals before
third learned advocate Ms. Jana
the
Kothari
writ
for the appellant.
is to be stayed, my lord. Proceedings itself to be stayed.
Also, there exists an arbitral award dated 10/10/22. The sole arbitrator allowed the claims put forth by the claimant The respondent hearing,
It was in favor of the respondent one. Yes.
respondent hearing. Tell it. Right. The arbitrator, sole arbitrator. Allowed the claims of the respondent hearing,
Number one. Respondent number.
respondent number one hearing with following directions. So just quote all directions, quote 27 to 420 up to 10 up to 429. Not 421, 428, 10, full stop. Two of the directions include that the respondents shall execute the sale deed and get them registered in favor of the claimant. It is the direction number 3 into bracket small Roman 3, that the respondents shall execute and register sale deed in favor of the claimant in respect of two awarded sites, which is number 5544 and 5573, carved out in survey number 3 in Krishna Nagar village. Full stop. It was submitted by learned senior advocate that he said arbitral award is subject matter of challenge at the instance of the appellant herein by filing appeal under section 34 of the Arbitration and Conciliation Act, seeking to set aside the same. Full stop. It was submitted that meanwhile, respondent number 2, who was party to the arbitral award, approached on a single judge by filing writ petition number 10696 of 23, in which the prayer was made to require the appellant hearing.
No, the prayer at page 42 is to direct BDA to execute it in my favor. When BDA,
Is to direct the Bangalore Development Authority to execute the sale deeds in respect of the said scheduled C sites in favor of the respondent 2 pursuant to the allotment letters dated 17/7/19. Full stop. Learned judge allowed the petition by judgment and order dated 15 January 25, which is the subject matter of challenge in this petition. It would be noticed from the judgment and order on a single judge that the effectum of appeal under section 34 of the Arbitration Act having been pending was known to learn a single judge, it could be seen. It transfers from the judgment and order of learned single judge, that judgment that he was apprised of the effectum of pendency of proceedings under section 34 of the Arbitration and Conciliation Act for setting aside of the award. In spite of that, learned single judge, it was submitted exercise jurisdiction and Article 226 of the Constitution and made following observations to finally allow the petition.
just an order, my lords. Petition is still pending. Petition.
Pending.
Yes, in
Pass-
fact,
And pass the interim order.
interim order on this.
Full stop. Interim order whereby the appellant is directed to execute.
No, BDA is directed.
BDA is directed to execute.
Sale deed in my
BDA directed to execute the sale deed in favor of the
appellant.
petitioner respondent. Full stop. Then quote paragraph 9. There is an award. Full stop. The order of learned single judge, not judgment. Don't write earlier judgment. The order of learned single is interim order. The order of learned single judge not only. Disposed of,
Oh, I'm
not
sorry.
entry model. It is not an
Sorry,
entry.
it is, I'm sorry, my mistake. They in fact
Judgment-
said that
judgment and-
the report to be filed and.
Court
we have
9,
to dispose.
Court 9, full stop. The, by allowing the petition and giving the direction as aforesaid to the BDA to execute the sale deed, or not only directly interjects the award of the arbitrator, which in fact is subject of challenge in the appellate proceedings, comma, the exercise of jurisdiction by allowing a single judge under Article 226 to issue such a direction, comma, in the facts and circumstances case is prima facie illegal. In that view, there shall be rule returnable on 21st April. The judgment and order of learned single judge shall remain stayed during
Very
the
much.
pendency of the petition.
Much,
This can't be permitted.
exactly, grateful man.
So 29 is urgent, still number 30. Vikram Munni Rajgopal. For 30.
Well, two questions will arise in this writ petition. Firstly, my lord, as to whether when a general lien subsists, a bank can be directed to return, my lord, a security document that they received. Second, my lord, is whether, my lord, the court below can pass an order which is beyond the prayers sought for even in the writ petition. So these are two questions in my respectful submission that will arise for consideration.
Yes, what is the order?
My lord, the order, my lord, will find at page 16.
You are a bank?
My lord,
You are a bank?
I am for the bank. If I may, my lord, directly take, my lord, first to the writ petition prayer at page 27 first. Kindly look at the prayer at page 27 first, my lord.
Yes.
My lord, kindly see, the factual background is this, my lord. The respondent here, the petitioner before the court below, my lord, applied for a housing loan from us. And my lord, towards that housing loan, my lord, we advance consideration for that purchase of the place. So my lord, the property in question was, the documents relating to that was deposited with us under a deposit of title deeds. Now, my lord, what happened was, he also has, being part of another company, he has taken, a loan was taken, in respect of which loan he's a guarantor. Now, my lord, even before any of these things could happen, there's a default of over 7 crores of rupees in that, as far as that debt is concerned. And a proceeding has been initiated before the Debt Recovery Tribunal in 2023 against this very respondent also. Now, my lord, the question is, then what he does, my lord, in 2024, he then says, I will get another bank to pay the money that is outstanding on this loan account, and therefore wants to take away. And on that basis, my lord, says that now please return all the original documents back to me, because this particular loan has been discharged. So this particular housing loan has been discharged because now Indian Overseas Bank is paying you that money. Please return the documents relating to this. To which, my lord, the bank's stand was that while this loan may still stand discharged once Indian Overseas Bank pays the money, my lord, the release of the documents, of these documents, will not be done because you still owe us about 7 crores of rupees, for which an OA is proceeding.
Show the provision of law by which you can exercise the general lien.
My lord, may I request my lord to kindly look at the Indian Contract Act for a minute.
Good.
May I request my lord to kindly look at section 148 first. What is it? 148, 171. Here it is. 171. May I read 148, my lord? A bailment is delivery of goods by one person to another for some purpose, and upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the direction of the person delivering them. The person delivering the goods is called the bailer, and the person to whom they are delivered is called the bailee. Explanation: if a person already in possession of goods of another contract to hold them as bailee, he thereby becomes a bailee and the owner of the goods of such so and so, although they may not have been delivered by way of bailment, etc. So 148 talks about bailment. Now kindly look at section 171. 171. Bankers, factors, wharfingers, attorneys of a high court, and policy brokers may, in the absence of, 171. Bankers, factors, wharfingers, attorneys of a high court, and policy brokers may, in the absence of a contract to the contrary, retain as security for a general balance of account any goods bailed to them, but no other person shall have the right to retain as securities for such balance goods bailed to them unless there is an express contract to that effect. So, not a banker, I'll ignore the others. Even in the absence of a contract to the contrary, has a right to retain as security for general balance of account any goods bailed to them. This right is not available to other persons.
Goods are defined.
My lord?
Goods
Goods, yes.
defined anywhere.
Goods, my lord, we will have to go back to, can I request, my lord, can I take, my lord, directly to a Supreme Court judgment, which refers to 171 and applies it to documents deposited with banks. Can I request, my lord, to kindly look at, my lord, there's a compilation of judgments that we had passed on 6th of January, my lord. Judgment compilation. Sixth January, the case. On the last date of hearing, I had passed it on.
Give only the one which cited, we'll get it.
Sorry, my lord, can I? It's the judgment of the Supreme Court in Syndicate Bank versus Vijay Kumar, 1992. I am aware.
1992 Supreme Court case.
1992 Supreme Court in Syndicate Bank versus Vijay Kumar.
Yes.
May I just, can I request now to kindly look at the first paragraph itself? I'll come to. The question involved in this appeal is, what is the meaning of banker's lien in the legal terminology and how it is understood and exercised in the banking system? The appellant is Syndicate Bank. I'll skip this for, if I may just summarize what is stated in that paragraph 1. In this case, what had happened was, a bank guarantee had to be given to court. Therefore, my lord, this particular person, he went to the bank and said, will you give me a bank guarantee? The banker said, you make the deposit of the sum with us in a fixed deposits, and I will give you a bank guarantee. So, my lord, so fixed deposits were open towards, my lord, issuance of bank guarantee. 90,000 rupees was the bank guarantee. Two fixed deposits were of 65 and 25,000 rupees were opened for the purpose of getting the bank to issue the bank guarantees. Subsequently, my lord, if my lord looks at the next page, the first line, the division bench of the High Court discharged the bank guarantee. So the bank guarantee stood discharged. Now, my lord, when the bank guarantee stood discharged, he approached the bank and said, please return my fixed deposits because I had given these fixed deposits towards issuance of the bank guarantee. Now, my lord, in paragraph 2, my lord, the contention was that the bank has a banker's lien over the amount by the judgment. Then, my lord, kindly go to paragraph 4. To appreciate these contentions, it becomes necessary to refer to some of the relevant documents and then examine the meaning and scope of the expression banker's lien and bank guarantee in the light of some of the settled principles. The two FDRs were fully discharged by signing on the reverse of each of them, etc. I skipped that. Can I go to paragraph 6 on the next page, where the court then examines what is banker's lien. In Halsbury's laws, lien is defined as follows. Lien is, in the primary sense, is a right in one man to retain that which is in his possession belonging to another until certain demands of the person in possession are satisfied. In this primary sense, it is given by law and not by contract. In Charmer on Bill of Exchange, a banker's lien on negotiable instrument has been judicially defined as an implied pledge. A bank has, in the absence of an agreement to the contrary, a lien on all bills received from a customer in the ordinary course of banking business in respect of any balance that may be due from such customer, and so on. Then chitty on contract. I just go to the last 2 lines on that page. The above passages goes to show that by mercantile system, the bank has a general lien over all forms of securities or negotiable instruments deposited by or on behalf of the customer in the ordinary course of banking business, and that the general lien is a valuable right of the banker, judicially recognized, and in the absence of an agreement to the contrary, the bank has a general lien
over securities or bills received from a customer in the ordinary course of the banking business and has a right to use the proceeds in respect of any balance that may be due from the customer by way of reduction of the customer's debit balance. Such a lien is also applicable to negotiable instruments, including FDRs, which are remitted to the bank by the customer for the purpose of collection. There is no gainsaying that such a lien extends to FDRs also, which are deposited by the customer. Now, applying these principles to the case before us, we are of the view that undoubtedly the appellant bank has a lien over the two FDRs. In any event, the two letters executed by the judgment debtor created a general lien in favor of the appellant bank over the two FDRs. Even otherwise, having due regard to the mercantile custom as judicially recognized, the banker has such a general lien over all forms of deposits or securities made by or on behalf of the customer in the ordinary course of banking business. Then, in the facts of this case, in paragraph 8, the High Court, however, found that the two FDRs were given only by way of securities for the bank guarantee. And once the bank guarantee is discharged, the amounts covered by the said two FDRs would belong to the judgment debtor, since the charge is limited to the amount of the bank guarantee. Kindly go to the last 6 lines of that paragraph. We are unable to agree with this reasoning. As already noticed, the recitals in the covering letter as extracted above clearly establish that a general lien was created in favor of the bank on the two FDRs. Merely because the two FDRs are also furnished as security for the issuance of bank guarantee, the general lien thus created cannot come to an end when the bank guarantee is discharged. Then the last 2 lines on that page in paragraph 11, because here also he was a guarantor in respect of another loan on the basis of which, my lord, this money was sought to be, the bank was seeking to exercise lien. Then the guarantee has been defined in so and so. A guarantee is an accessory contract whereby the promisor undertakes to be answerable to the promisee for the debt, default, or miscarriage of another person whose primary liability to the promisee must exist or be contemplated. In the banking system, it is understood that bank guarantees has a dual aspect. About 5 lines from the bottom of that on the right side, my lord. Now coming to its enforceability, the same depends on the terms upon which the guarantor was bound by himself, and he cannot be made liable for more than what he has undertaken, etc. Then, may I request my lord to go to paragraph 16. We have already held that the appellant bank has a general lien over those two FDRs. The High Court, having held that the two FDRs can be attached, gave a further direction dismissing the objection of the bank, and the bank should deposit an amount of rupees 35,000. As rightly contended by the learned counsel for the appellant bank, the bank in the instant case has a liberty to adjust from the proceeds of the two FDRs towards dues to the bank, and if there is a balance left, that will only be the amount which would belong to the depositor, namely the judgment debtor. In this case, and only such amount, if any, can be attached in discharge of a decree. And my lord, 3 lines after that. However, in the view taken by us above, namely that the bank has a general lien over the two FDRs, we set aside the order of the High Court, directing the appellant bank to deposit an amount of rupees 35,000. The High Court shall, however, consider the objections raised, etc., etc., etc. So, my lord, I kindly see the Honorable Supreme Court says that once, in this case, there was an FDR, but they say whether it is in the name of a negotiable instrument or in the nature of a security, it would be subject to a banker's lien under section 171 of the Contract Act. Now, my lord, same view has been taken in multiple judgments. My lord, I've produced a compilation of them. Kindly look at the next judgment of the Honorable Delhi High Court. No, I think it's at page 25, the judgment of the Honorable Delhi High Court.
Here it is said that title deeds are goods within the meaning of 171. Yes, what you have to say?
Can I just also point out one more thing? Apart from this, kindly look at the contract in the instant case. In the instant case, if my lord looks at the deposit of title deeds, which is at page 66, the deposit of title deeds makes it clear that it is not only in respect of this particular loan.
That is 66.
Page 66.
That you read last one, it is.
Malad.
Read it in consideration of the bank making country.
Malad. In consideration of the bank making or continuing to make advances or otherwise giving credits or offering other bank facilities like housing loans, so and so, so and so, for as long as it thinks fit, housing loan, mortgage loan center, Mysore, so and so, or any other branches up to a limit of so and so. On the exclusive interest discount, this the 9th day of April 2021, deposited with housing loan, with housing loan and mortgage loan center, bank branch of the bank in Mysore city. The title deed is described in Schedule A here and below, in respect of the immovable properties described in Schedule B here and below, with intent to create a mortgage by deposit of title deeds as security for due payment to the bank of all or any of the sums of money, which then or hereafter be or shall at any time be owing to the bank on account of a sum obtained or to be obtained hereafter by me, by /us/ the party, in any of my or our or the party's account, be it current, overdraft, cash credit, or loan, whether from me /us solely or from the party or from either of any of us jointly with any other person or persons, including the amounts of any notice or bills discounted or paid on or at the request of either of us solely or jointly, or any money advanced made to or from the accommodation or at the request of either of us solely or jointly for any money for which I or we or the party may be liable to the bank, or in any way whatsoever, together in all cases aforesaid, with the interest at the rates determined by the bank from time to time in this behalf, so and so, so and so. Then my lord, if my lord turns to the next page, which would be at page 68, clause number 2. We have agreed at the time of creation of the mortgage by deposit title deeds that the security created thereby shall be a continuing security and shall secure, notwithstanding that at any time thereon accounts are brought to credit or the facility is reduced or enhanced or further shall ensure for any other or fresh financial facilities that I or we or any of the parties may be granted by the bank or at any of their offices in India, and so on. So, my lord, the deposit of title deeds itself covers us for all liabilities that the petitioner, that the respondent herein owes the bank, quite apart from the general lien under section 171. Now, my lord, the only other thing that I wanted to point out was, now, my lord, if my lord looks at the impugned order, kindly look at the impugned order at page 17. The writ petition simply was to say that mandamus for release of documents. Now, kindly look at the order, my lord, at page 20. While, my lord, the writ petition itself is extracted, the prayer in the writ petition is extracted. Kindly see the nature of reliefs that have been granted in this order. Liberty, kindly see clause C. Liberty is reserved in favor of response 2 and 3 to prosecute proceedings initiated by them against the petitioner and others in relation to different properties other than the aforesaid property in law. So, my lord, this property has now been ring-fenced by the court below against my being able to proceed against it at any point of time. It is needless to state that the aforesaid proceedings initiated by response so and so in relation to different property, petitioner would be entitled to take up all defenses and contentions available in law, and all rival contentions in this regard are kept open and no opinion is expressed on the same exception.
Now, with regard to the other loan,
My lord,
set wherein he has given his personal guarantee. Have you invoked the personal guarantee?
we have invoked personal guarantee. We have initiated legal proceedings against him in the Debt Recovery Tribunal in 2023. And my lord, there's not a whisper of any of these things in his writ petition. There's no mention of this other liability, our stand that until that is discharged, we can't release the documents. No mention of any of this at all. And therefore, my lord, prayer C becomes even more stark because, my lord, the order is being passed in respect of a pending proceeding, stating that this property cannot be prosecuted in that proceeding, but when there's not even an averment about it in the writ petition. Well, the last two judgments in that compilation, my lord, are on the subject of granting reliefs which are not sought for at all in the writ petition. Those are, my lord, the judgments in Bharat Amritlal Kothari versus Dosu Khan.
Clause C is in your favor.
My lord?
Clause C of the operative part.
In the yes, my lord.
Liberty is reserved in favor of. It is in your favor?
No, my lord. No, my lord, it says, I can't proceed. My lord, although it says is reserved in favor of response 2 and 3, kindly go further. And others in relation, my lord, to prosecute proceedings initiated by them against the petitioner and others in relation to different property other than the aforesaid property in question. So therefore, my lord, the court says I can't proceed against this property. Although it's couched as if it is in my favor, what it does is it prevents me from proceeding against this property.
Yes. My lord, insofar as the proceedings before the DRT is concerned, which they've initiated proceedings and they have already taken an attachment in respect of properties worth more than about 30 crores. About 9 properties they have attached, excluding this. They have already taken. Nevertheless, my lords, I am made as a party there, though I have resigned from the company much prior to the account being classified as NPA in that company where they are alleging that I am still holding as a director post. Nevertheless, they admit that I have resigned from the directorship much prior to the class. We paid the entire loan loss by availing another loan from Indian Overseas Bank notes as produced at Annexure G. And the entire loan has been paid. Now, when I make a request to them, my lords, to release these original documents, they don't reply anything at all. Lords, that makes me to approach this honorable court, lords, for appropriate directions to release the original documents. Lords, in the very similar circumstances, lords, may I rely upon one judgment, lords, of the Bombay High Court? Where, lords, section 171 of the Contract Act has been considered.
So for the other set of loan transaction, you must have given different security.
There are other different securities which were given by the other directors of the company. Nevertheless, lords, the properties, I have never given any security in that company. But after the initiation of proceedings before the DRT, even my properties worth about 35 crores have been attached before judgment. There is an order of attachment operating against me. And even admittedly, according to them, according to me, the loan outstanding against that third party company is about 5 crores. They say it is 7 crores, whatever it is. But about 35 crores worth of property, who is one of the directors. I am one of the directors. Apart from properties of other directors of value of more than 10 crores are already attached. Apart from that, my properties worth 35 crores have been attached, and they don't want to release this now, lords. And this property, lords, I have availed loan from Indian Overseas Bank, and I have paid this loan. Now, Indian Overseas Bank, lords, is asking me the originals. Otherwise, they are saying they will freeze my account. Now, 2022, lords, SEC online. Lords, similar situations. Writ of mandamus, return of title documents. Petitioner seeking direction to the bank to return title deeds to enable them to deposit same with the other bank in view of the settlement of dues on the date of filing of the writ petition by arrangement made through another nationalized bank. Statement of accounts furnished by the appellant bank subsequent to the same was 0. Outstanding. High Court fully justified in issuing mandamus for return of title documents. Lords, Section 177, general lien is discussed, my lords. Withholding of documents of security, security documents kept with the bank as security are released, my lords. Now, I will take your lordships to para 9 of this judgment, lords, regarding discussion of Section 171. Now, the question is whether the respondent bank has general lien over the documents of security under Section 171 of the Indian Contract Act. The provision of Section 177 reads as under. Lords, para 11, Section 177 of the Act express the common law principles that if a man has an article delivered to him on the improvement of which he has to bestow trouble and express, he has the right to retain until his demand is paid. It is primary or legal sense. Lien means a right of common law in a person to retain that which is rightfully and continuously in his possession belonging to another until the present and accrued claims are satisfied. Thus, from the expression banker's lien, it is clear that bank's overall forms of security that are deposited by the borrower in the ordinary course of business, there has to be a relationship of banker and customer between them. In Brindio Barnett, it was stated as under bankers most undoubtedly has a general lien on securities deposited with them as bankers by customer unless there be an express contract or circumstance that show an implied contract inconsistent with the lien. It has been held by the mercantile system. The bank has a general lien over all forms of securities or negotiable instruments deposited by or on behalf of the customers in the ordinary course of business, banking business, and that the general lien is a valuable right of the banker judicially recognized in the absence of an agreement to the contrary. A banker has a general lien over such securities or bills received from the customer in ordinary course of banking business and has a right to proceed in respect of any balance that may be due from the customer by way of reduction of creditor's debt balance. Lien contemplated under 177 of the Act relates to goods bailed to the bank. Strictly, it is confined to securities and properties in the custody of a banker. Section 175 expresses goods bailed to them. The provision therefore indicates that the right to retain goods bailed is based on a contract, and retaining the same in the absence of contract is not permissible. Division bench in so and so held that bank cannot exercise its right of general lien over the title deeds deposited by the petitioner after the entire loan amount was fully repaid by the petitioners. It further held in para 10 of the judgment of division bench of this court reads as under. I'll skip that. Then para 12, my lords. In the present case also, petitioner has repaid the entire amount of loan regarding the loan obtained to purchase the flat. Petitioner has produced a record, Annexure K. The account extract shows that no balance amount remains to be paid in respect of loan account of the petitioner. It is also admitted by the respondent bank that petitioner has paid the entire amount against the loan which was obtained. Only contention of the respondent bank is that petitioner is also a borrower of Sunil High-Tech Company. The petitioner as well as other directors have obtained loan, but the said company went in liquidation and liquidator is appointed. The amount is due from the company. Petitioner, being a director of the said company, is liable to pay the amount, and therefore the documents regarding the title of property is not remitted by the bank. It is further submitted by the bank that bank has already moved an application before the Debt Recovery Tribunal, New Delhi, bearing original application so and so against the petitioner and others for recovery of the loan amount, which is due against the company, and the said application is pending for hearing. It is further submitted by the respondent bank that till the outcome of the order of Debt Recovery Tribunal, the respondent is unable to release the said documents. Thus, the material on record shows that petitioner has cleared the entire dues in respect of the loan which was obtained by him in the individual capacity to purchase the flat. The said loan transaction came to an end. Therefore, the relationship of banker and customer between the petitioner and the respondent in respect of the concerned loan account came to an end as he has repaid the amount. Relationship of banker and customer would not have been continued when the petitioner has repaid the entire amount on 31/5/2021 as the entire account is satisfied. Said transaction has been completed, and there is no further relationship between the petitioner and the respondent. Then I will come to para 15, lords. In view of the settlement of the dues on the date of filing of the writ petition by the arrangement made through another nationalized bank, namely State Bank of India, and statement of accounts furnished by the appellant subsequent to the same being 0/0 outstanding, the High Court was fully justified in issuing a writ of mandamus. Then para 17, referring to another judgment, lords, it says, admittedly, para 17, there was a relationship between the petitioner and respondent as a banker and customer. It is further cleared from the pleadings that title of the property in question was handed over to the respondent bank as a security. Admittedly, said loan amount is repaid by the petitioner, though the respondent bank has submitted that there is another loan account against the petitioner and bank has already moved an application to the DRT for obtaining necessary orders. Bank is at liberty to move against the petitioner and other directors to recover the said amount. Admittedly, said security was given against the loan amount which was already satisfied by the petitioner. In such a situation, it is not open for the respondent bank to continue to exercise its general lien for the security deposited with it, especially when the entire amount was paid. Such a general lease is not being exercised for a general balance of account as required under Section 171. Moreover, it would not be open for the bank to exercise its right of general lien for the securities on the pretext of banker and customer relationship. It cannot exercise such general lien under Section 171 of the said Act. Thus, there is no justification on the part of the respondent bank to retain the documents relying upon the provisions of Section 171. Then para 19, Lords, respondent bank has already filed an application before the DRT for attachment of property. Said application is already pending before the DRT and the respondent bank is exercising its right to recover the loan amount by attaching the property. Bank is at liberty to exercise its right by taking legal recourse to recover. But this liberty is already given to them. And Lords, it is not in dispute that they have initiated proceedings even in my case. And the proceedings are pending. And they have already obtained an attachment order in rest covering their, not only covering this, Lords, covering 4 times of what liability they say against me, Lords.
See, that is different. The issue is whether you are a customer of the bank or not.
Lords,
Now,
I am, yes.
See, the issue is if you are a customer of the bank, then the bank can exercise general lien. If you are not the customer of the bank, then the bank cannot exercise the general lien. Now, being a guarantor for another loan, personal guarantor for another loan, and after the personal guarantee has been invoked by making that particular loan an NPA, do you become the customer or not is the issue.
And in this case,
If the answer is you are not a customer, you are entitled for your property. If the answer is you are a customer, they can exercise the general lien. This judgment is not clear whether that person had given the personal guarantee or not.
He has, my Lords.
See, he was only, whatever you read shows that he was only a director. It does, paragraph number 18 has a reference to an element of guarantee coming in.
Even Bombay has divergent views earlier. Bombay High Court itself more than one judgment, but
My Lords will find, my Lords, at page, paragraph number 5, my Lords.
Bombay judgment.
Factual aspects.
Bombay judgment.
The judgment which I have relied upon.
Yes.
In response to the notice, may I read?
Yes.
In response to the notice, respondent bank has filed its reply. As per the respondent bank, petitioner has alternate efficacious remedy before the debt recovery tribunal, other firms so on. So therefore, petition needs to be dismissed. Is further contention of the respondent bank has filed an application before the DRT, original application number so and so against the petitioners and others for recovery of the loan. The petitioner is a guarantor, director, borrower of the company, namely Sunil Tech. The respondent bank has also moved an application for attachment of property owned.
Where are you reading?
Para 5 of the judgment notes.
So
which I relied-
guarantor in respect of very transaction
Yes, ma'am.
or different transaction.
Guarantor, director, borrower of the company.
Same.
In my case also, it is the same.
No, so guarantor, director, borrower is referable to same transaction.
It is, of course.
Of course.
And Lords, may I make one more submission, Lords, beyond this? Lords, all that the bank should be worried about is the security for the purpose of loan. Irrespective of this transaction, they are only worried about the security or their right to recover the amount in respect of other loans. Lords, they are not disputing, nor I am disputing with regard to the pendency of the application before the OA. And also, my lords, attachment being in respect of more than 35 crores worth of property. Lords, this would be, lords, covering about 8 times of what liability which they are claiming against me.
That will not be going into.
I understand, my lords, I understand, but it is an undisputed fact. It is an undisputed fact. Now, lords,
Being said for the first time, and they have not said a word of any of these things in the writ petition to say that they've not even disclosed the fact that there's another proceeding against him for recovery of money. Nothing is mentioned in the writ petition. And now to say that no, that the attached properties are worth more than 35 crores, not that's for the first time. It's not referred to in any of.
But nevertheless, lords, they themselves say, lords, they don't dispute about the pendency of OA proceedings.
This attachment aspect is on the record.
My lord,
That you are saying that your property is already attached.
there is an attachment.
It is on the record.
It is not there on record.
You want to,
I will furnish that.
you want to place on the record.
I will place it.
Also do a research whether this securities
Lords,
are,
moreover,
securities
lords,
are
even-
goods. So Delhi High Court has said the security are goods.
My lord.
Your lordships,
In fact, all of them take the same line.
Absence of a contract to the contract. Retain as a security for a general balance of account. When we say a general balance of account, it means this account is held by this particular person in his personal capacity, or it also pertains to another account. That's a gap. See, Mr. Arun,
My lord.
it's 171. Go to 171, both of you.
Sorry.
Both of you got 171?
yes,
My lord.
It's bankers, in the absence of a contract to the contrary, retain as a security for a general balance of accounts any goods billed to them. Now this general balance of account, should it belong to an account belonging to that particular person only, or can it also include an account where he has stood as a personal guarantor?
My lord,
see,
the moment the guarantee is invoked, my lord, it becomes a part of his account.
That research has to be done on this particular aspect and shows the case laws.
Well, I will look, my lord, if my lord were to have it another day, I will look that question up and make my submission.
See, he is having another account.
Yes. Is it part of the same?
Then there is no problem. But here it's a different account and the property is not mortgaged. He has given only personal guarantee. No doubt you have invoked the personal guarantee. That alone is sufficient to hold that the security, that the property can be retained as a security for a general balance of account.
Yes.
And it is immaterial about other things, about other goods that they are attaching and things like that.
My lord.
This becomes little more research.
Requires little more research.
My lord.
Or we can either way conclude.
My lord may fix a date a week from now, my lord.
in fact, my lords, they don't want to leave me as their customer because I have been a very good customer with them for last more than 25 years.
That is
I've been
different.
good.
All
Of
these
course,
things are immaterial.
that is, of course, it is only the legal
list
point
to
that
be
your lordships
decided.
are highlighting, but we'll come back.
Then in the week of
My lords, may I make one request, my lords?
10th
There is one
week-
contempt filed by me for compliance of this order, which is also listed today at serial number 64. If it can be, my lords, connected with this, my lords, for non-release of documents, I have filed a contempt, 64, my lords, item.
64. So this may be kept on 17th March.
Hello, 17th.
Connected with the contempt.
64 is being adjourned to the same date, my lord.
64 to be listed with retable number 1105. Is it 1105?
Great, great.
Seal number 31. Mr. Vinay Kirtiyam.
Appear for the appellant.
For respondent number 3, my lord.
Your lordship, in this matter, your lordship, in learned single judge passed the order with respect to the two writ petition. One writ petition was filed by me and one writ petition filed by them, where I questioned the assistant commissioner's order. So cancelling my caste certificate. So in that, your lordship, in connected matter, this honorable court disposed and reserving liberty me to challenge the subsequent events. After the disposal, that your lordship, my membership was cancelled and fresh election was conducted and new member was elected as a member. So that your lordship, this honorable court disposed the connected matter, which is the common order. Two appeals.
It has become infectious, my lord.
This has been touched. This is.
Yeah. One is writ petition. I challenged the order of assistant commissioner. They sought for the co-warrant of the performance of the order of the.
You will say any of the this order, this is also infectious.
My lords, already election have been conducted and Mr. Adarsh has been elected in the vacant post. So even this appeal will become infectious, my lord.
But about
Their co-warrant has been entertained by the petition and
If I may give the judgment passed by this court, my lord. I have the judgment. Order passed. Here's the judgment.
learned advocate for the party stated that the election is held.
yes, I believe in that petition, your lordship, in that order, liberty reserved to question the subsequent events.
In that view, the substratum of this petition stands extinguished and the appeal has been extinguished and the appeal has become, and the challenge in this appeal has become infectious. Also produced before the court. Order passed, order dated 8 January 2025. In writ appeal number 1172 of 24, which arise out of the very judgment and order impugned in this appeal, from which appeal is also disposed of, treating it as infectious, full stop. So present appeal will not survive accordingly and stand this.
Lords, one submission, my lords. This one's submission, serial number 47, my lords. I appeared for complainant in this case, my lords. Respondent number 2 has issued the endorsement, my lords. I may be permitted to challenge that endorsement and contempt may be dropped, my lords.
Learned advocate, Mr. Karthik.
47, yes.
Karthik stated, fairly stated that since endorsement is issued by the respondent, the directions of learned single judge are complied with and the contempt proceeding does not survive. In that view, full stop. The contempt petition is disposed of, not surviving. Full stop. It was requested to the court that the petitioner may be given liberty to challenge the said endorsement of the order. Full stop. Full stop. It is observed that such liberty is reserved. The petitioner may institute appropriate independent proceedings if so advised to challenge the order of legal endorsement on merits, in respect which, however, this court does not express anything on merits.
Serial number 57, my lord. Serial number 57, petition for complainant, petition may be dismissed as not present. Petition may be dismissed as not present because they have complied the orders of the single.
Manjunath P does not press the present contempt petition as the order is complied with, dismissed as
Please.
not surviving. Also, invite attention of the court to the memo dated 28/1/25 figuring on record of the petition, in which it is stated that the petition does not want to press the petition, present contempt, as the order passed in the writ petition number 1589 of 2021 is complied with. In that view, dismissed as not surviving. Yes, next.
Serial number 48, my lords. 48.
48.
For the complaints, my lords, a short accommodation may be granted for the complaint.
We'll go to 4th March.
Your Lordship, serial number 72, Your Lordship, process fees are paid in morning, Your Lordship.
72 process fee is not paid.
Your Lordship, paid your. Today morning I am paid.
It is stated that the process fee is paid today. In that view, the official list says the contempt petition.
Lordship,
12th March.
Your Lordship, serial number 73.1, Your Lordship, contempt matter. Your Lordship, some urgency, Your Lordship, kindly, in some urgency in this matter, Lordship, writ appeals also connected in this matter, Lordship. Now pension is not settled, Your Lordship. That's the reason.
Let us say it might.
Preliminary hearing, Your Lordship, short date, Your Lordship. Preliminary hearing, Your Lordship.
It will reach today.
Today, please. Your Lordship.
Likely to reach. Why don't you say it will not? Yes, where is that matrimonial matters?
Serial number 80.
Yeah, request your lordship, my lord, said 4:30 in the chambers because the child has gone to the school.
One submission.
I'll.
Child is not come.
My lord.
Child.
My lord.
Not able to come.
No.
The child has
will
come. My lord, may I make the submission?
No,
Before
the
my
child
friend
will
preempts my
I
submission.
will.
My lord, I'm very
also
grateful.
submitting.
I'm very grateful to my learned friend to have complied with the order of this court. My lord's order of 11th February, whereby my lord directed the respondent to comply with the order of the learned single judge against which the contempt petition was filed, the violation of which. And I'm very gracious and thankful to her that she made it possible that the order was complied last weekend. And my lord, let me say this with all happiness, that the children had a wonderful time with the father, and the grandparents. My lord, we have, in fact, it was a little anxious for us because the case of the other side was that the child was not willing to go. Even we were anxious,
Even
but
on
by
that date was
by
not-
God's grace, kindly see this.
The mother has made her efforts, definitely, and
I'm grateful to my friend.
even the last
having
minute,
enough
the child was
kindly
refusing to
see
go.
They had a wonderful time. In fact, when the time to return came, they were hesitant to go back, but the mother's company was, of course, necessary, and we prevailed upon them to go back to the mother. Kindly see. We have a video recording as well. Multiple videos, but video recording of the weekend. We can also show it on the system to the Honorable Court.
Then why there is a dispute between?
My lord,
Plus
they
the
have-
contempt itself
ma'am,
proceedings.
one minute.
In
I'll
fact,
just complete.
I don't think
I'll
the
I'll
order
answer
is
the
on
question.
record at
I'll
all.
I'll
In
answer the
fact, I do
question.
not know how we can.
This order was violated.
No.
Sorry.
Not on this. We are asking that what is the dispute between the spouses?
Well, between the spouses, my lord,
Spouses,
my
he's
client,
he's
my
looking
client
fine
was
for the
diagnosed with,
children now.
my client was
Doesn't-
diagnosed with cancer. On the day he was diagnosed with cancer, she left with the children.
That is not true.
I mean, that's
He's
maybe,
right.
I mean, that's a matter which I don't want to indulge.
MOE
So since
for
my lord
divorce.
asked the question, I answer the question. It may be disputed as a different matter, but there's no other trigger to it. In fact, a few weeks before, they went on an international tour as well, both husband and wife.
That's my
And
objection.
every year they've been traveling throughout the world and have had a happy time until he was diagnosed with cancer. That's a different matter. Since my lord posed the question, my lord, we are here in contempt against an order which was wrong, violated on the plea that the children did not want to go from 12th July 2024 onwards. And for the first time, it was complied pursuant to my lord's orders passed last time. All I seek is, my lord, we have no personal vendetta here or trying to take any personal scores on the other side. All we say is, let that order be complied henceforth as it was complied last week.
Plus, may I just request your lordship?
We
Just-
are not
just
going to press anything from this court for the violations made past. We have no intention of penalizing her for the contempt of the order.
Plus, may I just?
We have nothing at all.
Your
All
lordship,
we seek is compliance with the order henceforth, nothing else. And the
may I-
petition can be disposed of on those grounds.
May I urge your lordships to just look at the annexures that I have produced along with my reply, my lords.
Where is your?
Few of the my lords, annexures my lords, dated, reply dated my lords, 17th January 2025. Plus, I've produced some text messages where repeatedly the father tells about the child, my lords.
7 February.
17th January 2025, my lords. My reply.
Yes, 17 January.
17 January, my lords. Plus, few of the text messages would definitely reflect as to what state the father is in, not from now. From the time of matrimonial life, there are messages from 2016 repeatedly telling her
No,
about
we
the
are not
child.
in
I
appeal.
don't
All
think-
of
I
this
don't
was
think this is
produced.
right. I don't
All of
think
this
it
was
should be
produced before the
interfering
learned
when
civil
I'm
judge.
submitting.
We are not in
That is
appeal.
not right.
An appeal to the Supreme Court against the order was dismissed.
No, I don't understand.
We are not
how
in
it's
appeal. We
interfering
are not
with
in
my
appeal over that order. We are only reporting a violation of
Let
that
it
order.
finish, then I
It
will-
doesn't open,
Let
it
it
is not
finish.
open to her to reinvent the wheel in a contempt court when she took the matter to the Honorable Supreme Court and had to reach finality. And the application to modify that order also rejected. And even after rejection of the modification order, she has violated the order.
May I be
My lord,
permitted?
this is contempt at the maximum level.
This has gone to Supreme Court.
They went to the Supreme Court
May I-
challenging the order in which they are
I
in
will just
contempt.
point it out.
And
I will-
then that was suppressed because we were
Not
not
at all.
parties there.
Not
It
at
was suppressed through all the proceedings. Subsequent
That is not
modification she filed, she did not report to the court that she approached the Supreme Court and got it dismissed. And the modification was dismissed without reference to a dismissal in the Supreme Court. My lord, we are not here to penalize anybody. All we seek is the child should not be denied the company of the father, the limited access which was given by the 12th July 2024 order. Her past violations is something which we do not even want to look at. All we seek is henceforth a due compliance with the orders of the court, like the way my lord's orders were complied with.
May I be permitted to submit
Or
without
separated
interruption, my
after-
lords? May I?
After my lord's order for the first time.
After the birth of the child.
My
Sorry,
lords,
my
may
lord,
I, may I,
after-
may I just submit, my lords? After the,
Yes.
after
Yes,
the,
yes, after the birth.
my lords?
The parents separated after the birth of both the child.
Yes, yes.
Yes, barely when the
The
sex
day he
child
was diagnosed with cancer, she walked out of the house with the
Not
children.
at all. That is
No,
not
that's
true.
okay. We are not calling upon this court to decide on that. We just want to highlight the fact it may be disputed.
Both are staying at Bangalore. only.
They are staying at Bangalore within a kilometer's distance.
May I just take your lordships through the reply?
No, we are not here to reopen and re-agitate.
Definitely, but I think
You
I am
want to
entitled to
prejudice
my
the mind of
submission
the court, yeah.
also. In fact, my lords, the father has not given his consent for admission of the children to the school, and that matter they've taken that
She is
stay.
diverting every issue.
Why the council?
The issue here is compliance with the order
I'm
of 12. We are in
submitting.
contempt.
That is-
The issue.
I don't
She
see-
has to address herself to the compliance with the order
I don't understand why the council is
because
repeating.
you're diverting the court's attention to other matters. That's why.
May I request the council not to interfere me?
No, and allow you to prejudice the mind of the court?
That the court will decide.
Do you think we are diverted?
I'm sorry, no. My lord, all my request is this. I mean, I'm grateful that my lord's order was complied. I'm grateful to my friend, though belated compliance, it was complied with. And I owe it entirely to this honorable court and to this honorable bench that from 12th July 2024, for the first time on a weekend, the children went to the father and grandparents and they had a wonderful time. All we seek is this arrangement
Yes.
continue.
Let this cordiality continue.
That's all.
Yes,
That's all.
definitely. Having submitted that, I would definitely.
We will
like-
not even press the contempt
I
for the past
think,
violations.
Plus, I think I would want
Both
an
of you
audience
should,
with-
both of you should prevail over your respective clients to advise them that if they want to part, let them part. But let them part as mature adults.
Let's,
It should not have a bearing on the
Children.
upbringing of the child.
absolutely.
Not-
On that
My only
count,
fear was that the
the
alienation
children-
from 12th July
the
2024.
Children requires
the
father as well as mother. The love and
Absolutely.
affection of both father and mother.
absolutely.
But then my lord,
Absolutely.
You should
my friend didn't
be-
walk that path.
Mr. Manian, the
Sorry.
court is addressing,
Sorry. I'm sorry. My apologies.
part as mature adults.
Absolutely.
And don't poison the mind of the children.
Definitely, my lords. Absolutely. This is exactly the endeavor should be.
Don't poison the mind of the children.
My lords,
Let them have the love and affection of both the parents
True.
and the grandparents too, if any.
my lords. In
Okay?
fact,
No,
all
If
the
you
courts-
want, if you want to part, you part.
Because all the courts made an endeavor to call the father before the court. Now, where he has appeared till today, but I see him outside the
And
court right now. That's all.
You should be advising your respective clients accordingly.
Absolutely. My lords, he has
Okay, I
mentioned that
think
he's thrown her out of the club.
use your good offices to that effect.
In fact, I did approach him. I
That
told him.
that will resolve the issue.
Definitely, my
Lord
lords.
permits me, may I just make one
Absolutely.
submission, my lord?
In
We
fact,
have,
the
we
head
have
of
nothing
this
at all
court
with the contempt committed.
parties.
Thus far, we have no issues with the contempt committed. We would not call upon this court to pass any strictures on her. All we seek is compliance of my lord's direction passed earlier to continue henceforth and granting us liberty in the event it is again violated. With that, my lord, in a family matter, I wouldn't want this court to interfere, though there has been a contempt on the face of the record. I wouldn't want to interfere or ask this court to pass any such strictures on her. I'm not submitting on instructions, but considering it's a family matter and a sensitive issue, we don't want that to fester further relationship. All I seek is the compliance of this order for the future, granting us liberty to approach this court in the event of a violation again.
Plus, I would still like to point out few of the things filed with my reply.
Look at the tender age of both the child.
Yes, my lords.
They're very
Barely 10 months old, the second child was. They were thrown out of the house. And he approaches and file a custody petition asking various ex parte interim release. And the court feels that the respondent mother has to be heard. And on that,
all of this
he
was
feels-
submitted before the
This is
lower
another-
court,
I
before the
don't
learned
think I can
civil judge.
continue like this.
All
I'm
of
so
this was submitted before the Honorable Supreme Court.
sorry. I do not want to continue.
And
anymore
you
because I
violate the
don't
order
think
and you
I'm
want to
giving
re-agitate it
audience.
here.
Let him,
Please.
let us. Yes.
My lords, several applications seeking for ex parte interim release were filed by the father before the family court because she did not agree for the divorce that he demanded after throwing her out of the house. Barely 10 months old child, second child. Thereafter, he approaches the writ court, my lords, and the writ court passes a consent order wherein the father is permitted to meet the children every day between 3 to 6 p.m. and also grants a maintenance of 1 lakh.
Every settled.
No, my lords, every day, 3 to 6. That I have produced, my lords, at annexure. Your lordship will find it at annexure
There,
R3, my lords.
son is studying, daughter is not studying.
No,
My lords, no,
2.5 years old.
daughter is at
So there's
3
no
years.
overnight custody for the child. We understand the child is young. Only on a Saturday for a couple of hours, the child is sent. The boy is 5.5 years. He's allowed and he had a wonderful time. Both children had a wonderful time.
I don't think I'll be able to submit in the court, so.
Justify violation.
May I just?
Yes, now what is the solution from your standpoint?
Look, solution, yes.
They have given the solution. This it.
Yes.
Yes, my lords.
Yes.
No, definitely, I do understand. I've told my client whenever the boy,
They only say the father on behalf of the father.
my lords,
The child should continue to meet him, mingle.
yes, my
and
lord,
things-
always, the mother was never against it. That's exactly what I wanted to just show your lordship.
Mother is serving,
My lords,
mother is serving,
mother is,
is serving somewhere,
no, my lords, she's not working.
housewife.
Housewife,
As
yes.
per our-
That is the reason 1 lakh maintenance was awarded by the writ court. And also visitation was granted to the father every day between 3 to 6 p.m. because they don't stay so far away. And they thought, since the child is hardly 10 months old, there is high chances of reconciliation between the parties. But however, instead of reconciling or paying the mother or even exercising his visitation rights, he went from one court to the other. Several litigations were pending. And ultimately, he approached the Supreme Court. Supreme Court made it clear that the maintenance ordered by the court has to be paid by him. I'm sorry to say, but even as of now, the maintenance that is due from the father is about 5 lakhs. And though there is a condition in the writ court order, my lords, saying that the father has to pay the maintenance by 5th of every month, the father does not adhere to that. No maintenance is paid by that date. And even as of date, 5,25,000 or something is due from the father. And added to that, the father is refusing his consent for admission of the children to the regular school where family court has passed an order. In fact, that matter is listed before the learned single judge for final hearing because they've taken a stay on that order and the father is refusing his consent for admission of the children. I do not know what his intentions are by refusing consent. At one breath, he does not pay the maintenance. He runs from two habeas corpus petitions pending, my lords. And the last petition, which I have also produced the order, the court felt that both the parties should be called to the chamber. At that point, they withdraw the petition simply because the father does not want to come before the court at any point of time. Till today, he has not given his consent for mediation in the family court, my lords. Mediation has not happened in this case at all, because the father has refused to give his consent in spite of an order by the division bench of this court. The father comes and says, I do not give consent for mediation.
In principle, you have to agree that the child should continue to interact with the father.
My lords, this order, what happened, my lords, even in December, the court passes an order for vacation from 22nd to 27th. She takes the children every day to the father's house. From 10 to 6 p.m., they exercise the visitation rights. It's not as if he has not exercised.
So when you are going to pay the balance?
Maintenance is paid. My instructions are, that was a fast one pulled by my learned friend. And let me make this submission very clearly, that if there are any arrears on that front, which is not intimated to us, it will be cleared. And though we are contesting the maintenance matter without prejudice, we will be in compliance with orders of the court.
That appeal also.
And that was planted to prejudice the minds of the court. And my undertaking to the court is that will be met.
I don't understand
And
what
my lord,
kind of submission is that.
She
Why
refers,
prejudice the mind of the court repeatedly
she very
making such
selectively
kind of
refers, she
submissions
very selectively
and
refers
interfering with
to
my
the December
submissions.
10-day vacation, winter vacation, when she sent the child. Prior to that, Dasara vacation, Diwali vacation, all violated. Nothing of that is made.
I can point out everything, my lords.
Are both the parties present before the court?
No, I can keep my party present whichever date your lordship.
Why didn't you keep the child present? You are undertaking.
Look, the child is in school. That was the reason I just wanted to ask if any other time or in the chambers, I'm okay.
No, my
with
lord,
this.
in the light of, I have no difficulty at all. My lord's indulgence, since my lord wants it it's coming from the bench. But I had this in mind. My lord, when my lord passed the previous order, it was, yes, there was a contention that the child did not want to come. But in the light of the compliance and the way it turned out, it may not be required at all, because they are not also disputing. The child is very well happy with the father and the parents. This visit to the chamber is not to do with the children or the visitation rights. If she wants mediation to settle the main matter between spouses, that is a matter which she has to work out in the family court.
Why not why not before the?
No, I don't want to. I'm here. I have instructions only to see that the child has the pleasure of the company of both parents. This is my brief, and these proceedings are concerning that. If she wants an overall settlement, she can fish for it in those myriad proceedings in the family court.
I'm not fishing for anything.
You want a lump sum amount which she has in your mind, you can do that in the family court, and we'll definitely invite it. Whatever she has in mind in the family court, we will ask her. We need not go to a mediation center. I know it's an amount in her mind. Whatever it is, my lord, of course, it's an obligation from the husband's side. I do understand it. And if there is an amount, we'll definitely put forward to a client. But don't make use of it, holding back the children and holding them at ransom. That's not fair.
That again reiterates the fact that the father does not want to come before your lordships. That's exactly what
right here, madam.
Yes, I'll
Right
have my
there.
party present.
Right
I will keep both the parties present on
No,
whichever
but
date your
we
lordship.
don't want this proceeding to be diverted into a marriage settlement. If possible, yes, I leave it to the court. If it's possible, yes. I have nothing in the way. But the visitation rights, my lord, cannot be used as a tool for ransom.
This is not.
By denying.
Tool for?
For ransom, holding back the children.
Nobody is.
That is a wrong
From
statement.
12th July 2024.
That word
12th July 2024. Kindly see, the order was complied with only after my lord passed the order. As recent as 11th February.
My lords.
My lord's order, kindly see my lord's order.
Sometimes loud voice also becomes ransom for other side.
I'm so grateful.
I can do without the mic. I can do without.
I'm so grateful.
I can do without the mic. I can do without.
Without also.
Yes, definitely.
My lord, no.
So anyway,
Yes,
what
my
to
lords.
do now?
No. If
Let the order be complied with.
my lords, if
So both the parties may come, the child may
Definitely, my
also come.
lords.
Sorry, my lord.
definitely.
Both the parties may come personally, child also may come. We'll interact and then finally take call to pass the order.
Definitely, my lords. I'm okay.
Really required, my lord, I have no objection. But since a child in an atmosphere of a court system, I do not know whether it's advisable. I leave it to my lord. Because there is no difficulty about the child being happy with the father and the parents. The spouses, she wants a settlement.
Is the court not in the position of loco parentis?
It is, my lord. As I said, my lord, I leave it to my lords. Whatever my lord decides.
Let's
My lord wants to interact with the child, it's fine. But since the child has come today, may I make one small request?
You're not supposed to leave, you're supposed to submit to the court. In these matters, you are not supposed to leave to the court, you have to submit to the
I'm
court.
sorry, I leave it to the discretion of the honorable court. My lord, may I make this one?
We are trying to have a more cordiality, nothing more. We don't have any other interest.
Nothing at all, my lord, nothing at all. May I make one submission to the court? Just one submission. I'm sorry, my lord. My voice is too loud. I try to play it down.
No, we are cool, composed, calm. Only you are up and down.
My lord, Mr. Justice Arun would know, he's seen me for the last 30 years. My decibel levels are high by nature. It's not meant to, you know.
This is
That's
all in-
not right too.
all in lighter way. This is a human problem. We would like to intervene to some extent and have the things in right way.
Very,
That's all.
very.
Plus taking refuge in the saying, that the court knows.
Submission. This order should be complied with as it was complied with last week. It should be complied with.
That's the law. That order in contempt has to be complied.
Absolutely.
Unless it is practically not possible to comply with. And you are demonstrating that it is
Absolutely.
possible to comply. We know.
That's all, my lord. That's all.
We know.
Plus, apart from that, if the court feels that the parties have to be present, just the mother and the father along with the child, I'm most willing to keep the parties present, my lords, provided they are also okay with that. I'm not.
Then we are not forcing.
My lords?
Equally true. If you say that you are not, we'll record that. We'll record it in order that the parties do not want to appear before the court.
My lords,
Or the
correct,
parties want the
yes.
child to be before the court. We record it.
That is what they are saying, but
Cannot
I'm
going to cross our boundaries. It is very certain.
true, my lords. I'm perfectly all
Are
right
free
with
to
that.
make, either of you are make to such submission. Are free to make such submission.
My lords, I'm okay to keep my party
We
present.
don't have any, we are court of law, nothing more. So decide for yourself, both of you.
My lord, I'm here only, my lord, with due respect, my lord, I have nothing. It's not an adversarial proceeding as far as I see. My lord, I bow down to the court. All I seek is this, that parental, it has happened only because of my lord's intervention. I'm very grateful to the court, and my friend also has made it possible.
But are you not ready to send the child
No, my lords, nothing like.
regularly?
No, the child will go. Apart from that, I'm
If
just,
that submission is recorded, my lord,
this
I'm very
kind of
grateful.
interference, I will not be.
If that
subject
submission is
to-
recorded, my
Not
lord, I'll
able
be
to
very
submit
grateful.
at all more than 2 minutes. That is not right. The council cannot keep cutting me through.
That's personally on me.
That's
I'm
not
open to
right.
any criticism from the court, and my lord, I'm not new to criticism, my lord.
I will be given another
Due
date
respect.
where I will
Due
submit.
respect. I mean, my apology. It was not done with any move to bring any disrepute. It was only in the spirit of the argument.
No, we appreciate the advocacy.
Nothing at all. And I'm grateful to my friend for having made it possible. After all, a child spending time with a father, nothing more can be important than that.
Anyway,
My lords, may
Court
fix
had
the
an
date,
occasion-
I will,
the court had an occasion to pass the following order on 11/2/25, which was for the purpose of obtaining compliance of the directions passed by learned single judge, which are brought under contempt jurisdiction of this court. Paragraph, the order reads as under. Paragraph 2 before the court. While it was agreed and recorded that on the next day, that is today, the mother would keep the boy as the son, who is 7 years old.
Yeah,
6 years, not yet 6, but it's going to turn 6.
Present before the court to enable the court to interact with him. Also, the other child in respect to whom the visitation right is given by the learner single judge to the father is 10 months old. 10 months old.
No,
No,
2.5 years old.
2.5 years
Now
old.
now she is 2.5 years.
No, the order was passed on July 24. So she was
2.5 years old daughter. It was stated today paragraph that because that on account of the engagement in the school, the boy has not been able to personally come. Full stop. The absence is dispensed, the presence is dispensed with any of the reason given. Full stop. Both the sides represented by learned senior advocate so and so and learned advocate so and so respectively stated that pursuant to the last order, the respondent wife went to the residential house of the
Children were picked up. As per the direction, children were picked up from the respondent's home.
stated that in view of the directions, the children had gone to the house of the applicant father on 15 to 25, and they had spent time with the father and the grandparents.
The affidavit may be noted.
In this regard, the applicant has filed affidavit dated 28 to 25, which contains the averments and as annexures, the photographs indicating the
And pen drive.
meeting of the child's children with the father and the grandparents. The applicant is also annexed pen drive stated to be containing the
Video recordings.
recording of the moments of visitation. The affidavit is taken on record. As far as the photographs exhibiting the moments of visitation of the children to the house of the father and grandparent are concerned, they are vivid enough to demonstrate the live and joyous moments which parties had together. You are also present?
Milords, I was
No,
not present.
Unsupervised.
I was not.
Since the court is of the view that the cordiality not only between the children and the father on one hand and children and the grandfather on the other end, but also between the spouses should continue, the court asked learned advocate for the respondent mother as to whether she would be willing to continue to provide the interaction facility, interactive rights to the father by sending both the children to the father's residence. The response was very positive. Full stop. Before further order is passed, the court is inclined to have interaction with both the sides. Full stop. Learned advocates to the parties agreed that they would keep their respective clients present before the court on
whichever date the court fixes, my lords. After, preferably in the first week of March, my lords.
Along with the children.
Along
The petitioner's presence may be recorded.
No, on that day.
No, he's present today, madam.
No. On that day, the parties are called.
No, I'm only reporting that client is present.
Any date, my lords.
27.
I'm grateful, very grateful.
27th, my
Very
lords.
grateful.
At,
I'm grateful.
at
to my friend.
4:30 or.
We'll just talk and then dispose of.
Please, please,
Plus,
please.
should it be in the chambers or in
So
the
that
open?
we
No,
have-
let it be.
So that we have done our duty.
Absolutely. Let it be
Lord?
called in court. Absolutely, absolutely.
4:30, my
Very
lords.
grateful. No, let it be at 2:30, my lord.
Whenever you want.
2:30.
My lords, 4:30 would be
We can spend some 2 hours with the children before it's called to the cap. 2:30.
May I just make a submission? I think 4:30 would be appropriate considering that's also a weekday. And also I would just request your lordships to just the parents and the children and not the grandparents to be present. That's all. That's all my request is.
No, we want the grandparents also.
My lords, not the grandparents because there is some,
No, I oppose all these conditions. my lord.
Only apprehension on our part is that if there is some administrative meeting or administrative,
Yes.
will not be able to.
Let not a
much-
time
I
be
understand.
specified, 2:30 PM.
So 2:30.
2:30, my lords.
And we
2:30.
spend some 2 hours with the children. I'll be grateful. My lord will, my friend will
That's okay.
definitely accommodate me. And I'm grateful to her for having accommodated this weekend.
Plus just
Very
one,
grateful.
plus just one request. May I just, let there be a direction for the parents along with the children to be present and not the grandparents on either side.
I
either
oppose
side.
it. I oppose it.
But either side, even they will come and they'll
My
be shown
client
down
is a
that.
cancer survivor. He depends on his parents.
No, my lords, he is playing
Client
golf
is a cancer
everywhere.
survivor. He's supported by his
Because
parents.
he is playing
Yeah,
golf
it's a-
everywhere. I have the
Think of
photos.
it's the crisis which he's undergoing. His parents are his only support.
Let his sister come where she comes everywhere, my lords. His sister
No,
is
she
accompanying
can't
him.
dictate to me whom I should get. I'm sorry, that kind of an order is never heard of.
We have observed this.
My lord, I'm grateful.
That's great.
I'm grateful.
Because let there
Madam,
not be a show.
listen, in a marriage,
My lords.
in a marriage, when you marry, you do not marry that particular person alone.
Exactly.
No, my lords, the parents
You
from her side.
also marry the rights and obligations of that person.
So
It applies both ways.
Yes, my lords. Yes, that's exactly what
I
I'm
have no
saying.
objection
It
for their
applies-
parents coming.
Yes.
It applies
No
both
objection for
ways.
their parents
Correct,
coming.
because I don't want the
Yes,
parents to have a
one has
showdown,
to
that's all.
Understand,
There is no showdown.
a person has the role of a son or a daughter, as the case may be. He has the role as a husband or a wife. He
Definitely,
has
she
the
was there.
role of a
Look, it's because of her, the messages will
father
reflect.
or mother.
Because the
Okay.
matrimonial
And
life.
he has
not
the role in the society also.
True.
The marriage should not curtail the other person discharging his role in different dimensions.
My lords, if,
Very grateful.
if the messages were to be gone through.
That is very
it is-
true.
Yes, my
What
lords.
my brother says is very true.
Absolutely.
That is called the institution of marriage.
Absolutely, my lords.
Absolutely,
And
my
it is because
Very
of her that the marriage sustained for so long. The messages will reveal. It is because of the wife and the daughter-in-law. She made such efforts to keep them all together. Otherwise, the abuses that he has hurled against his parents, sister, there is no
I'm
dirt
sorry,
to it.
I'm sorry. This
In
is
fact,
uncalled
she
for.
kept them.
This is uncalled for. I mean, we are looking at
I
a,
think I'm
we are
entitled
looking
to
at a
make my
closure. I'm
submission
trying to
also.
walk that path.
Whenever I'm making a submission, he has always a
my
problem.
lord's
I don't
invitation-
understand that.
We are not interested in
My
your
lord's
past.
invitation is to settle the matter.
I just wanted to bring it to the notice of the court. Let there not be a showdown outside the court. That is all.
There's
Nothing
never
else.
been, there never will be. Grateful.
I'll keep my part. Great.
Number 81.
I appear for complaint, your lordship.
Office on yesterday, my lords submitted.
Yesterday, my lord, I could not be in contact with VC, my lord. I could not be present when the case was called yesterday. We couldn't get the connection of VC, my lord. I was not keeping well yesterday. It was listed yesterday, actually.
Today is not present.
Yeah. My lord, no, they have filed a
Yesterday,
complaint.
yesterday the following order was passed by the court. That after quoting, contempt petition was ordered to post it today. It was called out in the second half. As was specially kept. Full stop. Today also learned advocate for the complainant is not present.
I am very much.
For the respondent is not present. Full stop.
May I
As the
make one submission, my lords.
compliance.
One submission, my lords. Yesterday I reported about the compliance, my lords. That is an order dated 31/20/25. Subsequently, my lords, certain conditions were imposed on order dated 31/20/25. One such condition has been removed and a fresh order has been passed on 15/2/28/25. That may be taken on record, my lords, for kind consideration. Whereas
Today
No
also
such
learned
condition can be
respondent
imposed,
is-
your lordship, getting
respondent is-
a genealogical tree,
Respondent is absent.
getting a consent from all the family members.
Then he must be not knowing again.
This is Kannada.
Sorry, my lords, one pertaining
The
to
conditions,
for
my lord,
production
which
of
is not
income proof was
contemplated
one of the
under
conditions was
provisions
imposed, my
of
lords.
KEC PDS Control Order 1992 or under 2016.
There were three conditions
These
in the
conditions, my lord, is not contemplated under the rules. They have to transfer the license, they have to transfer, that's all.
Who is for the complainant? You are.
I am appearing for the complaint. your lord.
Then it is over, matter is
It's
over.
over,
What
my
is wrong?
Now, this condition, my lord, they have to remove, your lordship. I can't go on getting the consent from any
I'll start
family
only for the
members.
family tree and the no objection from the,
Why family tree and all those things is unnecessary, my lord. The law does not require.
there is an objection filed by one of the sister of the
You
company.
place this on record.
Please, ma'am.
By memo, with memo.
Please, I'll place it, ma'am.
It was stated today by.
That they should remove the condition number 1 and 2, my lord.
Advocate for Learned Additional Government Advisor Raghavendra that press order is passed dated 15/2/25 incorporating or dropping.
Dropping one condition.
One
ma'am.
of the conditions, the said new.
Pertaining
the
to income
press-
proof.
Said press order shall be placed on record along with the memo.
Please, my lords.
Put up on 4th of March.
Yes.
Please, ma'am.
All the cases like this, my lord, they passes this order much while violating the division bench ruling, my lord.
It's only because, my lords, the
After
one-
I issued a legal notice, my lord, then they fight this second order. And in that, they will raise untenable objections, which is not contemplated under the order. Therefore, it has to be dealt with the iron hand, my lord, with these kind of officers.
Number 82. The PT case.
Same matter?
No, my lord, this is
No.
regarding.
please.
My lord, we are submitting compliance affidavit, my lord. And copy is served.
I've received the copy now, my lord, but my submission is that there is no compliance.
What is the decision to be taken regarding
My lord, please.
taking back them in service?
Please,
My lord, no, the order is, my lord. Order of the learned single judge may read the order of the learned annexure A, please, my lords.
Ask the parties to sit down. Ask your clients to sit down.
Great. My lords, may I read the order of the learned single judge, my lords, of which complaint is made. Operative portion of the order, my lord. It is allowed R3, that is the nursing council, my lords, at the annexure A of the complaint, directed to take cognizance of the order dated 18/1/24, passed by R2, and take appropriate decision in the matter, in accordance with the law, with an outer limit of 8 weeks. My lord, these are all contract workers supplied by the manpower agency. Well, R2 medical council, my lord, issued endorsement, look into this and take action and see that if they can be accommodated in another department. This is the order of 18-1, my lords, with the learned single judge says. We considered this, my lords, and we have considered this
For R2.
R
Your
for the accused in this, please, only R3 is made as the accused, my lords.
Your R2, R3. You appear for whom?
R3, please, my lords. R3 is made as the accused, my lord. He has to comply with R3 has to comply with the direction of R2 pursuant to the learned single judge order. And my lord, pursuant to this, endorsement issued R1 compliance report, my lords. This on 3/6/2024. What we have said is, my lords, the order dated 18/1/2024 is to consider, and we issued a letter to the manpower agency, my lord, look into the matter whether they can be accommodated in any other department. Order of learned single judge is to take appropriate decision in the matter, my lords, in accordance with the law. There is no direction for regularization or taking them back to services, my lord, because we don't have any employer-employee relationship with the complainants or the workers who are employed by the manpower agency. In fact, the order of the learned single judge, my lord, to consider the.
May I, my lords? My lords, the order of the learned single judge, at the outset, the outsourcing agency is not a party in the writ petition. The learned single judge's order was, R3 is hereby directed to take cognizance of the order dated 18/1/2024.
Where is the order passed by number 2?
My lord, that is at page number 32 of the complaint. Thirty-two, my lords.
Number 2 is Director of Medical.
Please, please.
My lord, the last portion, operative portion of the order, in terms of the opinion in the.
Now you have to comply with this order, this direction.
Please.
Take a decision whether you want to comply with or this round and round thing will
No,
not.
my lord, the last operative, that order, my lords,
No.
please. Directed to take appropriate action to permit the employees working outsourcing contract basis to report to duty and assign them work in the department other than they were working previously. This is the direction, my lords, by R2.
In terms of the opinion report, you are directed to take appropriate action to permit the employees working on outsourcing contract basis to report on duty and assign them to work in department other than where they are working previously.
Please, take appropriate action.
This
please.
is a direction by Director of Medical Education to the Nursing Council.
Please, my lords. Please, my lords.
Learned single judge says.
Please.
Page number 23.
Take appropriate action.
Is directed to take cognizance of the order.
Please, my lords, please.
Pass by number 2 and take appropriate decision. So take a decision.
We will take a decision, my lords. Now, my lords, this.
You're producing is not a decision.
We will again consider this, my lords.
Address to the court.
Please.
We won't any commentary from any authority.
That's true, my lords.
Ask your president not to treat the court's order like this in this session.
Please, my lord, please.
No speeches in black and white.
That should not have been.
Yes.
That should not, because outsourcing.
Say yes or no.
Yes, please. That we will.
And we'll test on merits.
That's
all. Yes.
We will come out with a better compliance report, my lords. But
compliance affidavit filed on behalf of number 2, number 3.
Number 3, my lords, and on the accused, my lords.
Would hardly be said to be satisfactory, inasmuch as the order of endorsement dated 7/2/25 produced cannot be said to be a compliance of the directions of learned single judge, full stop, learned advocate, Mr. So-and-so at this stage states that the respondent to nursing council shall pass appropriate orders in compliance of the wills. What is the language? Let us see, pass the appropriate, take the appropriate decision.
My lord,
Very
appropriate decision, my lords.
Just permit the employees back
No, no, that's
into
not the appropriate decision, my lords.
learned single judge's order is.
They want to expand it.
Take appropriate decision in accordance with law.
Please, my lord, we'll take appropriate decision. Please, my lords. My lords,
Put upon when?
after 2 weeks, my lords.
2
please.
weeks?
After 2 weeks, my lords.
11th of March?
Please, would your lords
11th
kindly?
11th of March.
As my lord, please. May I also make one submission, my lords?
Pardon?
Notwithstanding, my lords, these submissions we have made compliance, my lord. One appeal is also filed, my lords, challenging under single judge.
Appeal is also filed?
Please, my lords, we'll place under that also. If your lordship is pleased to direct it to be placed.
When appeal is, then we will not make this appeal.
That's why we'll pass on, my lord. But of course, they woke up little later, my lords. Long back they issued that detailed, as my lord said, a detailed order, my lords.
While the compliance affidavit and the order public endorsement produced together with it would not be said to be compliance of the directions of learned single judge, in course of the hearing today, it was submitted by learned advocate for respondent 3 nursing council that the appeal is filed with respect of the order and the contempt.
I will furnish.
Which is the appeal
Number.
Appeal number?
Number 280 of 2025.
280 of 2025.
Being with appeal number 280 of 2025.
Number kodi madhya.
When it is going to come out?
Your lordship.
The register is directed to list the appeal.
Both together.
On 17th March,
Please.
for which date all the office officers shall be
Please.
complied with. The present contempt petition shall be listed along with the appeal.
Please, we are greatly. Please.
May I make one submission?
Yes.
The single judge's order is 1st April 2024, my lord. After the previous hearing in this contempt, an appeal has been filed now.
They have right to file, right to contest.
Please. We are greatly.
Seal number 83, Mr. Malla Reddy.
We to file a memo, my lords.
What is this? Seal number 83. So it is over?
I permit to file a memo along with the translated copy, my lord.
What
Letter
you
has
are
been
producing?
addressed, my lords, to the Commissioner
You are
PDA, my lords,
producing what?
for the approval,
Approval, provisional.
provisional approval, my lords.
Provisional approval has been granted by the government, please, my lord, for incorporating the amendment. So as directed by this honorable court, please, my lord. And it is to be done by the Bangalore Development Authority Commissioner, please, my lord, Commissioner Bangalore Development Authority. And I think they may exercise all these things. It may take about 3 weeks or 4 weeks, according to my information, what they pleaded. please, my lord. It may be adjourned by another about 3 weeks or so. By the time they may comply and incorporate the amendment, please, my lord, that will be over.
Where is the direction? Where is it?
Direction is at
Lordship should get it at
page.
there is a page number 32, please, my lord, that is order.
32.
On being
31,
31.
31, last paragraph.
31, last paragraph. In view of the aforesaid submission, this petition is allowed. The respond number 1 and 2 are directed to forthwith consider affecting appropriate modification in the revised master plan 2015 by exercising power under section 17 of Karnataka General Clause Act 1899. This shall be complied within a period of 6 months from the date of receipt of the certified copy of this order. It is needless to mention that the respond number 1 and 2 shall make adequate provision for continuity of the 80 feet road up to the eastern boundary of survey number 69/7 of Sadarbangla village and beyond up to the boundary of the local planning area in the revised master plan for Bangalore. It is for being spoken to, the provision of law has been changed from section 17 to section 21, that is in page number 32. And it is confirmed by your lordships, please, mirror, that is at 35 pages. So time period has been extended by 3 months, please, mirror. That was. In CDP 1995 and subsequent CDPs, the 40 feet wide road was provided between particular survey numbers, please, my lord. That was left out in 2015, please. my lord.
So this provisional certificate is about,
The government has to approve before incorporating the thing by the planning authority, being the BDA.
what steps remains to be taken?
Now the BD had to take steps, my lords. Now we are given.
Now we'll have to notify it and call for objection. After 60 days objection period is there.
It must be a statutory timetable.
That is a statutory time.
It may be adjourned by. Otherwise, they will not.
Further survive, I may make this thing further survive. If any objections come, then what we'll have to
No, this is-
consider those objections. If the objection doesn't come, then it will get automatically incorporated.
When you are notifying the objections.
It has to be from 60 days from the date of communication by the government, that is from 15 to 2025, my lord, 60.
This is a direction issued by the Honorable
From
Court.
15
No
to
question of
2025, my lord,
considering the
16 days,
objections,
60 days
please, my lord.
thereafter,
60.
60 days. It may be by my end of April, my lords, April.
That
15.
is, if the government itself initiates this process, please, my lord, they have to call for objections and all those things. It is a direction given by the Honorable Court after considering all the material, because it was previously, in all previous CDPs, it was there. Intentionally, with the influence of certain influential land mafia, they have omitted this.
Any of the submissions made by learned counsel to the parties and having regard to the contents of the compliance affidavit, compliance memo. In memo, dated 28/2/25, filed by this phone number, filed by learned additional.
One, my number, 1 and 3 months.
Together with the copy of the provisional certificate, provisional approval. Provisional approval dated by 15/2/25, it transpires that the process of compliance of directions of learned single judge is underway. Full stop. Learned advocate for the petitioner, Mr. So-and-so, requested the court to adjourn the contempt petition to be apprised of at a later stage about the progress of the compliance. Stand over to 7th April.
Yes. April.
Arvindian, 84.
Nobody is there. Let you go. None present. Stand over to 8th April.
85, sir. Number 86.
My lords, I appear on behalf of the respondent number 3 and 4. Senior counsel is out of station, my lords. This matter may kindly be taken up next week.
My lord, these are the two matters connected, my lords, pertaining to survey, my lords, archaeological department, my lords had disposed of one writ petition, holding that the archaeological survey should consider whether the structure is within the limits or is there a damage or not, and disposed of. This, my lord, same building, regarding the tender process, there's a challenge. My lords had said this can come after the decision, my lords.
After the outcome, I have
After,
the
this is my
copy.
lord's order.
The outcome is
After NMA decides the issue, this petition was directed to be posted, that
No.
it can
No,
be
no decision
posted
is
after 1 month or so. Decision is not
Please, my
taken.
lord, no decision is yet taken, my lords, in other
8th
case.
of 8th of April. 8th April?
Yes,
No,
ma'am.
my
Yes,
interim, right?
8th April.
Yes, any day, my lords.
Any day.
Please. If in fact, we may be permitted to submit, my lords, if it is disposed of. Otherwise, my lords, date need not be given, only because if it is not disposed of, my lords, we may be given liberty, my lords, to move, if at all
Parties are at liberty to move earlier, to move for early date by filing interim application.
Please, please.
If the occasion arises.
Fair enough.
Please,
Fair enough.
most grateful.
Bill number 87. The Purnima. Bill number 87.
Who appears? Yeah.
Per se, my lords, it is not a public interest petition. Lords, may I just pass on, my lords, the,
Okay, come to page number 19.
lords, I have seen, my lords. I
Have you removed that
No, my
wall
lords,
on the road?
It is a private property, my lords. That is why. They have, my lords, not disclosed the products. I have also enclosed, my lords, that particular plan along with the present status also. And the petitioner, my lords, the first petitioner, who is the owner of, my lords, site number 43, has not disclosed, my lords, that she is owning site number 43. And what she wants, my lords, is that the private land where, my lords, there are some blocks that has to be removed and the road is to be formed. My lords, in order to form that road, my lords, I have to acquire. And this is, my lords, a private unauthorized layout, which is not approved layout. And that particular portion, my lords, is a private property, even as on date. Lords, kindly come to, my lords, page number 5 and page number 6, my lords, in the memo, which I have placed on record. It is a Kacha layout plan, my lords, page number 5. Site number 43, my lords, is owned by the first petitioner. So far as, my lords, half of the site to the extent of 22 feet, she has an access, my lords, towards that road. That is, that road is developed till such, my lords, position. Now kindly come to, my lords, page number 6. That yellow portion, my lords, is a different property altogether, owned by respondent number 7 and 8. What she wants, my lords, is that the road is to be connected to the next road by, my lords, forming the road. Still, my lords, it is a private land. And that particular aspect, my lords, is concealed, my lords, in the present writ petition.
So they have formed an illegal layout over there.
Yes, my lords. It is owned by, my lords, respondent number 7 and 8. If that road is formed, my lords, then her, my lords, claim is that she will get, my lords, the road for the entire property. Both the layouts are, my lords, unauthorized or unapproved layouts.
Disputed land is an earmarked plot
Yes, my lords.
of private party.
Yes, my lords. Road is developed, my lords, till yellow portion that we have developed it. And she has an access.
Unplanned land.
Both are illegal.
Not there. Learned advocate for Mr. Subramaniam R. files memo along with the document, which is in taken on record, paragraph. Learned advocate, the petitioner is not present. That will stand over to. When shall we keep? 19th, 18th March.
Yes. Bill number 88, the Chandrasekhar Y, party in person. Bill number 88, the Chandrasekhar Y, party in person.
Following order was passed on 24/1/25 in court the order. Even today learned registered intimated. Oh, we'll be able to know. Not intimate. Intimated. The record shows that the part in person was addressed to communication by the registered lady post, which has returned with endorsement that no such person is residing at the address post. For the last chance, to be listed on 18th March.
Yes, number 32.
Here for the appellant.
Milords, the complainants before your lordships, milords, were all site owners, milords. There were around 10 site owners around, out of milords, 55 sites, milords, which were formed in one survey number, milords, which was illegally demolished, milords, by the Tahsildar without issuance of notice to the petitioners. Milords,
Lord, may I
the
request the
learned
lordship
single
to-
judge, milords, your lordships may kindly see the order of the learned single judge. Milords, they have produced it at Annexure A, milords. A batch of petitions, milords, were filed. Many of the landowners filed separate petitions, milords. Two orders, milords, are before your lordships. At page 14, milords. Page 17, milords, is the relevant portion.
My writ appeal, my lord.
If your lordships could kindly go to para 6, milords, page 21. Para 5 was our contention, milords. Page 20 was our contentions. May I read para 5, milords? It is further submitted by the learned counsel for the petitioners that notice at Annexure Q has also not been served on the petitioners, who are the site holders, and upon inquiry, it is found out that the notices have been served on the Secretary of the Welfare Association. Learned counsel for the petitioners further contends that the Tahsildar has no jurisdiction to issue notice at Annexure Q, as the property is falling within the jurisdiction to which Karnataka Land Grabbing Prohibition Act 2011. If at all the authorities find that there is some encroachment, proceedings to be initiated under provisions of the Act. It is further submitted that in the case of encroachment, there has to be a survey in presence of the affected parties.
You are appellant.
Milord?
You are appellant.
No, milords, I am the complainant. That's why I'm.
Let the appeal.
Lord,
I'm sorry, milords. I thought I was the complainant.
Lord, my writ appeal, I'm only aggrieved by the portion of the order, my lord. My appeal is limited only to one direction. If lordship may kindly take the impugned order, which is at page 14, my lord. Lordship will, at page 24, there are directions issued by the learned single judge for conducting survey, my lord. Survey has been conducted now, my lord. Survey has been conducted
It's
on
not been
20th.
conducted.
No, let me just complete. survey has been carried out on 20th of December 2023, my lord. Lordship may kindly see para 9A, my lord. Notice was issued on 11th of December 23. In presence of the petitioners, survey has been carried out. Survey sketch has been furnished to them by way of an RPD on 3rd of February 2025, my lord. Now, my only limited grievance on account of the subsequent event which we have carried out where survey has taken place, my lord. The learned single judge at para 11, Lordship kindly turns to page 25, my lord. Possession has been directed to be handed over within 10 days from the date of receipt of the certified copy. Now, my lord, the petitioners claim to have purchased sites in survey number 175, my lord. Survey number 175. It's our case that survey number 416, my lord, 416, which was renumbered, which is Kharab land, measuring 6 acres, 7 guntas, belongs to the state government. It's a government Kharab land. I have produced by way of additional documents that this survey number 416, my lord, has been carved out of survey number 175 from 1946 onwards. Now I have produced those documents. Now, pursuant to the survey, my lord, what we intend to do is initiate proceedings under 104 of the Karnataka Land Revenue Act and complete that inquiry within a time-bound manner within 2 months, my lord. So I am only seeking your lordship's indulgence insofar as the possession is concerned, my lord. The survey number 416, my lord. Lordship may kindly take volume 2 at page 399, my lord. Page 399. I have produced 6 documents. The very first document, your lordship will find there at page, the English translation. (406) may be seen. Current typed version is 408, my lord. 408. This is a survey tipney. Lordship will see survey number 416. 408, my lord, page volume 2. Translated copy. Yes. Lordship got it. This is, Lordship sees, the date is 26th of June 1946, my lord. Survey number 416. It's government Kharab. This 416 is carved out of survey number 175, my lord. It is resurveyed and new survey number is 416, which is a government Kharab land, my lord. I have produced other documents also, my lord, which discloses that it is a government Kharab land. Now, petitioners, my lord, they have purchased sites, nearly 1,500 sites were formed, my lord, in survey number 175 by Bemel Association. And some of the sites, my lord, was falling within this survey number 416. My lord. Now, we had issued notice which was set aside by the learned single judge. Direction in the impugned order has been complied with. We have carried out the survey, my lord. Survey sketch has been provided to them. Even in the contempt proceedings, we have filed it by way of an IA, my lord. We will go ahead with an inquiry under section 104 of the Karnataka Land Revenue Act.
104.
104, my lord, which has been amended, giving power to the Tahsildar. Section 39 and section 104 are 2 provisions which enable the state government to remove encroachment on its land, my lord. We will give them an opportunity and complete the inquiry within a time-bound manner of 2 months, my lord. I am only agreed with the direction with regard to possession. So therefore, my lord, we will even place the report before this honorable court, my lord. This matter may be heard after 2 months. By then, we will complete the inquiry. There, my lord, if your lordship kindly sees, at page 46 of their writ petition, my lord, page 46, para 9, page 46, my lord, just 3 lines. There is no record to show that survey number 175 is renumbered as survey number 416 as alleged at present by revenue authorities. That is their contention, my lord. We have answered that by producing revenue records to show existence of survey number 416, measuring 6 acres, 7 guntas, which is a Karab land, my lord. We will hold an inquiry, my lord. Only limited indulgence today I am seeking from your lordship is with regard to the possession where I am directed to be handed over. That's all.
May I take your lordships to section 104, my lords, of Karnataka Land Revenue Act? It has no application in this matter at all. Tahsildar does not have powers, my lords, after the special court, my lords, is formed by the state government. There is a procedure, my lords, contemplated under the Land Grabbing Act, my lords, where the proceedings are civil in nature and also criminal in nature. Evidences are led. My lords, may I request your lordships to go section 104, which my learned friend is relaying upon right now.
But there is an amendment in January 25 this year. And the learned single judge has left open, either I can approach the land grabbing court or take recourse to the Land Revenue Act. That discretion is left open by the learned single judge for the state government. There is an amendment to the section 104.
How much time you will take in completing
My
the?
lords,
2 months, less than 2 months time.
my lords, may I make submission, my lords? My lords, it has to go before the land grabbing court was the submission, my lords, by the learned government advocate himself, my lords, before the learned single judge. May I read section 104, my lords?
Lord, operating portion of the order may be seen, my lord.
I'm requesting for 104.
No, just with
Let him
regard to
finish, my
that,
lords. He-
no, just one submission on that front, my lord. Lordship may kindly take para 8 of the impugned order at page 23, my lord. Page 23. Impugned order, my lord, last few sentences. Accordingly, the notice at annexed Q is set aside. Liberty is reserved to the respondents to take action as per law in terms of provisions of the Karnataka 23, my lord, page 23. Last few sentences. Liberty is reserved to the respondents to take action as per law in terms of provisions of the Karnataka Land Grabbing Prohibition Act or as may be permissible under the provisions of the Karnataka Land Revenue Act. So discretion has been given to the state government, plot. We would now like to invoke under the Land Revenue Act, that notice has not yet been issued to them, my lord. We are in the process of issuing that notice. All said and done, my lord, an inquiry has to be conducted and full opportunity will be given to them.
May I read page 21, para 7, my lords, if my learned friend has finished. Shall I start, sir?
Yes.
Para 7, my lords. There were a batch of petition, my lords, all those around 6 acres, my lords, including 2 acres, 28 guntas, my lords, where the sites of the petitioners or the complainants, my lords, is situated, was illegally demolished, my lords, by the Tahsildar without issuance of any notice, my lords, without giving us any note, my lords, that they're going to do this. Para 7, my lords, was an order that was passed in the connected matter. May I read, my lords, para 7? Page 21, my lords. May I, my lords? Page 21 of their writ appeal. May I, my lords? Peruse the observations made in WP number so-and-so, which reads as follows. It is noticed that in terms of the order at Annexure B, the Tahsildar has found that there is an encroachment of government land with respect to the land to an extent of 6 acres, 7 guntas in new survey number 416, old number 175 of Bagalur village, Jala Hobli, Yelahanka Taluk, Bangalore, on the basis of the report submitted by the Taluka surveyor and revenue inspector, and accordingly it is directed for recovery of possession of such encroached land. Learned counsel appearing for the petitioner submits that Tahsildar has no jurisdiction to pass an order pursuant to the notice at Annexure A, as action for recovery of land encroached by private parties will have to be done by following the procedure under the provisions of Karnataka Land Grabbing Prohibition Act 2011, where such government land falls within the jurisdiction of the authorities specified under the Act. It is submitted that the officer concerned is required to follow the procedure under the Act if the officer is of the opinion that there is encroachment of government land. My lords, it is settled law, my lords, that if the land falls within the jurisdiction of the land grabbing court, my lords, the Act must be invoked and the Tahsildar, my lords, does not get any authority. Learned additional government advocate submits that the procedure under the Act ought to have been followed. Kindly, my lords, your lordships may kindly take para 4, my lords, where the learned government advocate himself says, yes, kindly see, my lords, page 22, para 4 of the order, my lords, kindly para 4, my lords. Learned additional government advocate submits that the procedure under the Act ought to have been followed, and once specific procedure is provided under the Act would apply. Question of going back to the provisions under the Karnataka Land Revenue Act, which would apply in normal circumstances, would not apply. Accordingly, the notice at Annexure A followed by the order at Annexure B are set aside. Liberty is reserved to the respondents to take action in terms of provisions of Karnataka Land Grabbing Prohibition Act. Taking note that the present properties of the petitioners in form of sites is a part of old survey number 175 of Bagalur village, Jala Hobli, Bengaluru North Taluk, which the government claims to be the new survey number 416, and noticing that in WP number so-and-so, in so far at the same village, order is passed and observations are extracted as above, the present petition is also to be disposed of in the similar terms. Accordingly, the notice is set aside, and my learned friend read, my lords, both under land grab. Both at,
See, what is set aside is Annexure Q.
yes, my lords.
Come to Annexure Q.
Yes, my lords.
Page number 299.
299, my lords. My lords,
Page number 299 is a notice issued
my
by the Tahsildar.
yes, yes, my lords.
Okay. Calling upon you people to come and answer.
Not us. The notice is not issued to us at all. That was our grievance.
Okay. It was issued as against
Some Nutana Badavane Niveshanadara Kshama.
some society. It is issued to a particular society.
Yes, my lords, not to us.
Now, your contention is your lands and your valuable rights over the property is affected by virtue of Annexure Q.
Yes, my lords.
So you preferred.
And the act subsequent to it, my lords. They issue this letter within 4 days. They come and demolish. My lords, may
Yes,
request
correct.
your lordships to
Then-
kindly go to the photograph, my lords, Annexure T3, page 357, my lords. My lords, I'll demonstrate why this assumed importance is.
Okay.
Kindly see page.
They also demolished certain structures standing on the land,
Yes, and the whole sites, my lords, whatever was formed.
which belongs to you people and not the society as such.
Yes, yes. Society is a welfare society.
Welfare society, not the society as such.
No.
Aggrieved by that, you preferred a writ petition.
Yes, my lord.
Now, in the writ petition, you're not in appeal, they are in appeal.
Yes, my lord.
You are happy with the order passed
Yes, yes, yes.
by the learned single
Yes, my
judge.
lords.
Now, in the writ petition, Annexure Q has been set aside.
Yes, my lords.
Okay.
Yes,
They are given the liberty to initiate appropriate action in accordance with law,
Yes, my lord.
either under the land grabbing provisions
Yes.
or under the KLR Act.
Yes, my lord. Yes, my lords.
Now, they have opted to proceed under
My lords, kindly
the
see,
amended 104 of KLR Act.
kindly see 104, my lords. Even the amendment doesn't give them any powers. Kindly see
That's a
104.
separate thing to be agitated by you.
That's right, my lords. But my lords,
Now,
when
listen.
it is so
They have given them that particular liberty.
correct, my lords.
Now, what is found is that your action in issuing Annexure Q to be illegal.
Yes.
And the action initiated by you after passing that Annexure Q order to be illegal. That is forcibly taking possession of the property. So what is directed is within 10 days, you hand over back the possession. then you conduct the necessary inquiry under the KLR Act or land grabbing provisions as the case may be, then you initiate appropriate action in accordance with law.
Yes.
If they are agreed, they will once again challenge it.
Yes.
I don't think you should have any grievance about handing back the possession of the property is concerned.
One submission on that front.
Because the finding of the court, you cannot challenge only the 10 days issue. Because the finding of the court is, you have taken possession of the property by virtue of issuing annexure Q. Now, issuance of annexure Q is found to be bad. Then the consequent action should be called bad in law. Now, unless you challenge setting aside annexure Q, you cannot be saying that I won't hand over back the possession of the property.
No, my lord.
Kindly see one more order that was passed, my lords, at page.
What happened? Annexure Q is set aside. This is the law.
Correct.
They issue. And subsequent to it, they take possession of it.
Yes.
Annexure Q is set aside. Then they are directed to hand over back the possession because annexure Q is not issued. It is not issued the person or possession of the property, but society. Then liberty is reserved to them to initiate appropriate proceedings in accordance. The question of setting aside only this is not right.
Who is in possession?
My lord, there is no structure.
How will it be? They have demolished
No, no,
everything.
I'll just, no, there's no structure.
They've demolished.
It was a metal road, unfinished drain, and few electric.
My lords,
poles.
in a welfare
There were-
state, they make such submissions, my lords. It's almost like I do not have the rule of law, where the Tahsildar says, I will come demolish. If it is a concrete structure where you have spent 3 crores, only then I will have. My lords, we had formed layout. 55 sites were formed. Drains were there. My lords, kindly see why this is of importance is there are high-handedness. Kindly see page 358, my lords. Your lordships will realize who is behind all this. Kindly see page 358, my lords. It is because of the pressure from this huge, this person, my lords, all this is happening.
It's all factually incorrect.
It is not factually incorrect. My lords, as soon as the demolition happened, this was there in a private communication by this person, my lords.
No, this
How
is-
will, my lords, the allottees of these sites, my lords, are all scheduled caste and scheduled tribes. They were all class 3, class 4 employees of BEMEL, my lords. We have purchased properties right from 1994. We have been in possession, my lords. We have kata in our favor. The land is converted for non-agricultural purposes. There are plans that are sanctioned by the authorities at that point of time. All of a sudden, my lords, one day the Tahsildar comes with a bulldozer. My lords, today, the land is extremely valuable, my lords. It's very close to the airport. It's extremely valuable. My lords, I can put it on a fidavit by an official, my lords, that they demanded certain amount of land which we did not give. My lords, today the Tahsildar has gone to the Panchayat and asked for cancellation of all 1,500 katas which has been done, which is there before another court, my lords. All the 1,500 katas which were in our names, my lords, from 1994, 1995 onwards is cancelled. My lords, they want to coerce us. There is nothing legal here. My lords, my learned friend says, we'll do all illegality. We will keep the land. We will initiate. My lords, they initiate revenue proceedings. They will do it in their favor. Kindly see another order, my lords. Can I request your lordships to go to page 384? There was another order, my lords. This will show how high-handed they behaved. There were a batch of petitions, batch of people, my lords, who ran to this honorable court in 6 acres.
Lord,
this was 384. This petition is still pending before the learned single judge, my lords. On 59, this is also under the same notice, 384, my lords. Kindly see, my lords, what happened. May I read, my lords? They demolished the structure, my lords, in spite of the interim order that was communicated to the Tahsildar. The Tahsildar demolished. That is why this order was passed in the connected matter, my lords. Whether there must be an interim order restraining the respondents from continuing to demolish the construction and the property identified, page 384, my lords, annexure AD. as bearing survey number 175, new survey number 416.
Where is the annexure Q? Which is set aside
May I make one submission?
299, my lords.
299.
My lords,
Lord, may I make one
they
sub-
take over property, my lords. We are not on a fundamental right, but constitutional right, my lords. They issue such notices and they throw us out, my lords. 299, 301 is the. They declare we are encroachers, my lords.
My lord, what was
Can we see,
available
my lords, I
was
have-
only 57 acres, my lord. What was available and converted,
we are
if
not
their
at
rights are,
57
I
acres
just
now.
submit, my lord, their rights can be crystallized only to 57 acres. They have formed a layout in 84 acres by forming 1,500 sites, my lord. We don't want an inch of their private land, my lord. We are entitled to protect our own land. Their grievance in the writ petition is there is no existence of survey number 1416. I have pointed out how there is a survey number 416 which measures 6 acres, 7 guntas.
If your lordships want to, my lords, kindly see 404, my lords. My lords, this survey number.
Correct.
We'll keep it on 10th of March.
Lord, in this case, what has happened, my lord? The society has formed the layout. They are all purchases from the society, my lord. The society has encroached on this land.
They should make the society
All
a
I'm saying,
party.
my lord, all I'm saying,
Society is
this
not
is a
made a
Bemmel
party.
society, my lord.
Where are they? They have not made it a
They-
party.
All this, my lord, now, my lord, they said when we issued notice to the society, they say individually we have not been served. Now, when I serve them individually,
have
my lord,
s-
and want to initiate
I'm
action,
sorry, they have
this-
served on the welfare association which is formed after Nutana Badavane. Kshemadabhivrudhi Sangha is a welfare association which is formed only to see Morinal neer hogutta, mane munde neer nintkolutta anta nodake. We don't do anything beyond that. Avrige kodtare notice. Our secretary ge the arrest warrant is issued. ಅವರು ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಸೊಸೈಟಿ ಅಂತ ಇವರಿಗೆ ಸಾವಿರ ಸತಿ ಹೋಗಿ ಹೇಳಿದೀವಿ.
English is the language of the.
I don't want my honorable Chief Justice to understand what I'm trying to tell. ನಾವು ಅಷ್ಟೇ ಮಾಡುದು.
So adjourn on the ground of breach of natural justice.
I'm tired convincing my learned revenue authorities that we have no part in forming the layout. It is the Bemmel Society which is formed, which is closed after allotting all the sites. We are a welfare association formed after sites are formed.
Kindly supply the translation. Yes.
I'm sorry, my
Date,
lords, I
my
didn't
lord,
get
I
the
request for a date.
date. I didn't.
10th.
March.
Grateful.
Number 33. Pradeep Esoka.
Delay.
Appellants in this case.
Delay of 240.
Pardon me, my lords.
Delay will come down.
Very well, very well.
Only delay come down, appeal to be listed on 17th March.
Lord,
Short
EA for
question is
stay and then arguments on merits would be the same. Because the only issue, my lord, is a very short issue. My lord, the respondent had applied for voluntary retirement under the pension regulations, under regulation 29. Now, my lord, he gave a notice of seeking retirement under that provision. And my lord, 3 months was the time notice period that was required. Before the end of 3 months, my lord, the regulation requires acceptance. And then if no communication regarding acceptance or rejection is given, then my lord, it is deemed acceptance. Now, my lord, we gave the rejection on the ground that, my lord, he is facing some disciplinary action. Therefore, my lord, the learned single judge holds that the day on which, my lord, he has given the application, because we did not do it within 3 months from that date and not from the date when it becomes effective, the learned single judge holds he is deemed to have retired. That's the only issue, my lord.
There are two findings, my lords. Firstly, my lords, the communication.
Yes.
Seal number 34. 17th March.
70.
Number 34, Mr. Sharath S. Gogi.
Here for petitioner. Appellate. 57 days delay. 57 days delay.
Hold on. You gave me the delay con, elected in chapter.
It's relating to my lord's adopted.
Bill will come up on 19th March.
19th March. Seal number 35.
Much okay.
Mr. Nataraj Ballard.
My lords, this matter pertains to, my lords, where orderlies have been employed by in the police services, my lords. In fact, my lords, what I have suggested is, in fact, there's an order already to withdraw the services, my lords. There are around 373 orderlies who are working in various police departments, my lords. Given 2 months to 3 months time, my lords, we'll make fresh recruitments, relieve all these people, my lords. In fact, that is we're taking the finance department clearance. This is going more than 100 years, my lords. Now we have sought to sort out the issue between the government and the basically they're seeking implementation of our own government order. My lords. Can I permit you to read the memo, the document, my lord? With reference to the subjects cited above, proposal has been received from DG and IGP for creation of 373 followers posts to perform the duties of orderlies while letter dated so and so. Action has been taken after obtaining action has to be taken after obtaining financial department opinion for the proposal to create 370 followers post. The same has been sent to finance department. Action will be taken as soon as the finance department is received. Now, one more thing, will not only 2 months to get the finance clearance, plus make procedure to appoint this followers in the place of orderlies.
This is also, they are challenging the order of appointment of orderlies.
No, what they are saying is, my lord, we have taken a decision to withdraw orderlies from all the police force.
Where is
And
that?
that is that annexure A, my lord.
Annexure A, my lord.
That
Annexure
translated
A,
copy is at,
It is withdrawal or appointment?
your lordship may kindly turn to page 19, 20, my lord. Page 20.
They're in their residence, please.
So therefore, we are sorting it out. We'll have a meeting with the thing. We'll remove all the orderlies, appoint followers, my lords, in the place of orderlies.
Maybe you can appoint peons or something like that,
Yeah, we're doing that.
but not,
Group, in fact, my lords, we are appointing Group D employees that follow the Group D employees, my lords. And we'll train them, and what is, in fact, my lords, it may be in public interest, my lords. But the question is, if we ask these orderlies to relieve them, they'll be the saddest person, because they, instead of working in the sun, sun and the dust, my lords, they are comfortable working 8 hours in the house. Now, if we relieve them, they'll, I think, be after the petitioners here. But as your lordships, in fact, pointed out,
it can be humiliating for many persons.
that's the point, my lords. We are rectifying that. Given some reasonable period of time, my lords, we'll do it. That is what the crux is, my lords. To the qualification, they should be posted.
So what do you want?
The lordship may
suggest
take this on.
Lord, according to my instructions, my lord, there are more than 3,000 orderlies, my lord. Now that the AG is saying that it is 373, I don't have any information regarding the actual figures, my lord. So all the orderlies who have been deputed, my lord, maybe.
Page 4 of annexure A, of the impugned order, page 20, my lords. Page 20. The lordship may kindly, the number is given, page 20.
Page 20.
373 is the number which we are given, who are working. We'll remove all of them. And your lordship may say that no orders will be appointed henceforth. It's not that 370, any other working. This is a number which is there who are working. So, Roshim, I have it.
They will not give a response.
In fact, kindly grant reasonable time to implement annexure A, my lord. Well, the prayer at page 10 is to implement annexure. Kindly grant reasonable period to implement annexure A, my lord. If this
But subsequent to this order also, my lord, which is impugned here in, my lord, for which I am seeking a mandamus. Quoting that order, my lord, further orderlies are being deputed. My lord, kindly see page number 32 to 32, 56, 58, where I have put the translations, my lord. Tumkur battalion, they are deputing orderlies based on this order, my lord.
Find out what time will take in this process. 10th March.
Number 36, Ganpati Bhatt.
1 week time may be granted. 1 week time may be granted. 1 week time may be granted. Time. Second appeal. As requested by learned advocate. As requested by learned advocate.
Number 37, to Srinivas TP.
Or the petitioner in this case.
Lord, appearing for respond number
Not
6
for
in
some
this case, my
instruction.
lord.
Please, I'll place on.
Time 37. What is it about?
My lord, it is about a building constructed on an ala encroaching the public lana, which is meant for the flow of tank water, my lord.
Not for
He
instruction.
wants time. 24th March. As requested by learned respondent.
38 is urgent. Number 39, Mr. Sadanand G. Shastri. Petition PL.
BBMP should file the response today, my lord, in this. This is a matter relating to a PIL.
Because we have to identify where the land stands in, survey number 95. And we've written to the survey department to help us identify by surveying the lands. They're yet to respond. A short accommodation will be filed.
May I make one submission? Sufficient time was granted to the BBMP.
Okay,
My contention was this, my lord, in survey number 12 of Korbangla village, there's an open playground that has been encroached by the Passport Seva Kendra, which is the respondent number 5, and they're going on with constructions. With cogent evidence and proof, my lord, I've provided the photograph. In fact, the ex-transport minister has played cricket games on the very same playground. All of that is produced before this honorable court. Surprisingly, my lord, the Passport Seva Kendra, they were granted 3 acres of land as far back as in the year 1994. Subsequent to that, my lord, first time in the year 2023, after the revenue survey happens, they realize that they do not have any right, title, and interest over the property. They write to the government seeking that reallot the survey number, my lord. Now, thousands of students who are in the nearby areas are using that playground. It has been closed. As of today, 1 year is completed, my lord.
The issue is whether survey number 95 belongs to BBMP or not, my lords. We are unable to identify that land. We've asked the survey department to
You're
identify.
still to file reply.
My lords?
You not file reply, so
No, my lords, I believe.
file. Learned advocate for the BBMP wants to file reply and or to
Shortest
20
possible date, my lord.
26th of March.
Any shorter date, my lord. Because the students, even the schools, my lord, in the neighboring areas, they've written to the BBMP itself that we have been using this playground as our playground and the children need the playground, my lord. Only this submission may I place, my lord. The Passport Seva Kendra is trying to construct
Reply may be filed on or before 17th. The petition may be listed on 26th.
Not the Passport Seva Kendra is going on with construction of an auditorium. No passport office is there. Some kind of non-precipitative action, my lord, kindly. It's been 1 year, my lord. The school students, they've not been able to use the playground. Just a humble request, my lord, I leave it to the court, my lord, but seriously, my lord, there is some encroachment that has happened because 2 years earlier photograph I also have produced, and your lordship on the last day rightly pointed out that the compound wall clearly depicts in the photographs that I have produced that it could not have been the land of the Passport Seva Kendra. Looking at the students, my lord, I am here before this honorable court, nothing else, my lord. I leave it to your lordship.
So 40 is adjourned. So number 41,
Great.
Anish Acharya. 41, Mr. Anish Acharya.
Lord, may make a request that matter will be taken up tomorrow, my lord, if it is possible.
What is this?
This is with regard to the penalty which is imposed on the petitioner, my lord, with regard to by the NGT, my lord. That is under question.
My lord, 117
My lord,
crores is to be paid towards the environmental compensation which they had undertaken to pay.
my lord, we have undertaken to pay. There are, once the NGT order was passed, my lord, there were several general direction and specific direction which was given. We have complied with most of the direction which is given, my lord. Certain direction which is we were unable to comply. We are writing letters to them with regard to these directions, my lord, how to comply and how there are certain when the environmental clearance has to be given, everything has been spelled out in the NGT order, my lord. Maybe taken up tomorrow. I'll make my submissions on that, my lord.
You want when? 17.
My lord,
When do you want?
any date convenient, my lord.
My lord, if I may make one submission, I appear for the impleading applicant. I am the petitioner before the NGT. I appear for a civil society organization. If my application may be allowed, my lords, because the pendency of these proceedings is being sought as a basis to adjourn those proceedings.
My lord, they have no locus standi. The entire question is with regard to the letters which is being addressed to the Karnataka State Pollution Control Board and with regard to the order, show cause notice which is issued by Karnataka State Pollution Control Board. I'll file my objections to the impleading application which they have.
The matter was set down before the NGT for final hearing. They file a
28.
My lord.
28.
So number 42, the Veerabhadra MC, 42.
Nobody is there. Give some date.
I'm for the accused saying this.
42, you're in 42.
It's under process, my lord. Kindly grant 1 week time, my lord. It's under process, my lord.
So number 43, Mr. Kantraj T.
Ismail. My lord, I'm representing the association wherein the respondent number 3 has issued a notice to the respondent number 2 saying that, okay, the STP is not proper. They will have to maintain it properly. But what happened is respondent number 2, that is the builder, has issued a notice to the association saying that they will no longer continue to maintain the STP, which is not as per the case PCB guidelines, my lord. That is how that particular STP is not taken over for the maintenance by the association, my lord. They have recently issued a notice. I just may pass on the copies, my lord. Saying that, okay, they will discontinue maintaining this STP, my lord. One side, this KSPCB has issued a notice where they have not renewed the license from 30th 9 2023, and whereas here this builder who was supposed to maintain this is saying that, okay, I will no longer continue to maintain the STP, which he should have done it because we are not taken over only because it is not as per the guidelines which is set by the KSPCB, my lord.
My lords, I appear for the second respondent promoter in this matter, my lords. My submission is that the STP is fully compliant and it is way back in 2021 that the entire project is handed over to the association for maintenance. It is for reasons best known to the petitioner and the association, my lords, why the STP is not taken over, and in good faith we have maintained the STP till now. The water tests have been carried out. So it's in that background that the notice is issued requesting the association to take handover, my lords. One second submission, my lords, it's a RERA registered project and they have rights under the act to take over the project and then seek for defect liability, my lords. And my instructions are that the STP is fully functional and it is fully compliant to the KSPCB norms. And if the notice that my learned friend is referring to, which is an annexure in the IEA filed by my learned friend annexure AG, my lords, that is, please, my lords.
Where is the notice? Where is the order?
That is IA2, my lord.
Your Lordship, appearing for Pollution Control Board.
My lords, the last page of that notice may be looked into. It's also marked to the association, and that is in view of the fact that the project is taken over by the association. And if there's anything to be complied with, we are more than ready to comply, but in my knowledge and our instructions, my lords, everything is complied with, and let the association be directed to take handover fully, my lords. That is my humble request. And insofar as the writ petition is concerned, there's no relief that is sought against R2.
My lord,
Reply is filed.
I made the reply also to their
Where is
notice, my lord. No, I got the copies of this, my lord. I just wanted to hand it over. My lord, this particular STP,
What is filing? Joint. Where is the reply?
we have also made the reply to case PCB, my lord. I have the copies of that also. No, they don't file the
Replies
Yeah, no,
so
not-
far not filed by the respondent. If any reply is to be filed, the same shall be filed. Before the next date put upon.
My lord, the earlier date, my lord, because they are saying that they are going to stop maintaining that, whereas they've used a ASP process, that is accumulated process, sludge process, which supposed to be adopted for 500 KLD, my lord. This one is a smaller one. This is below 50 KLD, my lord. And also when they took up the repair of that, they have reduced it to 30 KLD, my lord. That is what is saying. I can show all those annexes, my lord.
All right. 25th March.
Your Lordship, appearing for Pollution Control Board, I have one small submission. The petition papers may be kindly given it to us so that we can seek instructions, Your Lordship.
My lord, it is given, my lord. Petition papers are
We have
given.
IA copies, Your Lordship. Petition, writ petition, we do not have. Your
It is
Lordship.
also given.
You copy.
Number 44, Mr. Sunil Kumar H.
Petition, my lord. So this petition is filed seeking, my lord, compensation and rehabilitation for the victims who lost their houses due to landslides in Uttar Kannada district, my lord. The state has to file their objections in that. Reply is not filed. The state has to file their objections in this matter.
My lord, the prayer may be seen, my lord. It is to provide. State hasn't, my lord, formed any scheme, but they are seeking for a direction to the respondent to provide rehabilitation and compensation to these villagers. They have given a representation to that effect.
You have to take instructions.
I'll get the instructions, my lord, because I don't think the state has any. I'll get a formal communication from the DC Revenue.
But in fact, Annexure C, the deputy commissioner himself says, my lord, there's a policy of 15 lakhs that could be given to each
That
family.
is by the central government.
Even the DC can coordinate and give it to us, my lord. My lord, more than 1,000 of families, they've lost their houses, lands, farm, everything has been lost. Now the state can't say that we don't pay even compensation to anyone else. Now they're left to fend for themselves. It's a humanitarian cause, my lord.
It was declared or not declared?
They have not declared anything. They have not even given minimum compensation to us. We lost the cattle, we lost the land and houses also. And now, my lord, Annexure C, The Deputy Commissioner has quoted a policy of the central government wherein under the National Tiger Project, 15 lakhs could be given to each family and we could be relocated else. Even that is also not done. Their own letter at Annexure C states that. At least something could be given to them. Thousand families are there.
My lord may grant me 2 weeks time.
19th March.
Please.
Like,
Great.
So number 45, the green bench matter.
Appearing for petitioner, my lordship. My lordship, I am seeking for the writ of mandamus. Last occasion, my lordship, the government advocate has produced one endorsement, my lordship, stating that it cannot be granted. My lordship, I produced an additional document along with the requesting this honorable court to appoint a commissioner, my lordship. To promote the illegal quarrying, my lordship, they are not granting quarrying lease in my favor. My lordship, I have produced the photographs before this honorable court to show that there are illegal quarrying activity has been carrying on by the other persons. To promote them, my lordship, such a rejection endorsement has been issued in favor of against the petitioner, my lordship. Kindly see, my lordship, I have produced the 10 photographs which has been taken in the January, my lordship. And also I have submitted a representation to the second respondent contending that, my lordship, there is a illegal quarrying is going on along with the photograph. But he has not taken any steps to stop, either to stop the illegal quarrying or to grant in my favor. This is virtually, my lordship, legality and illegality before this honorable court.
Here in the writ petition, my lord, is for mandamus to consider their application for quarrying lease, my lord. That has been considered now and an endorsement has been issued. That has been placed before your lordship. Now, if they are aggrieved by this endorsement, my lord, they have a revision remedy, my lord, under 53.
They want to continue with the
Immediate
illegality.
relief sought is for mandamus, my
honorable
lord,
court has
to
no
consider their
jurisdiction
application.
as
Their
if-
application has now been considered and an order has been passed, an endorsement has been issued. That has been placed before your lordship on 19 January 25, my lord. If they are aggrieved by the endorsement, my lord, of rejection of their license, my lord, they have a remedy of revision under 53.
Earlier rejection
But
order,
the
my
prayer
lordship,
is,
I made a
transferred.
revision petition and I have obtained an order in my favor, my lordship. The authority has directed to consider my application, my lordship. They are easily promoting the illegal activity. They are looting the natural resources, my lordship, and they are not caring for any legality at all.
Lordship, may kindly see the memo dated 19 January 25, my lord. 19 January.
That's what, my lordship, in reply for that, I have produced
A memo has been
additional
placed.
document along with the photographs to show that to promote the illegality, they have made such a, issued such a endorsement.
Memo dated.
My lord, filed on 11th February, my lord.
On the last occasion, my lordship, they have issued the endorsement, produced the endorsement, my lordship. To counter that, my lordship, I made an
Filed in the
application.
counter on 11th February 25, my lord. Memo is dated as 8 January 25. The endorsement translated version is at page number 4, my lord.
They are saying, my lordship, there is a gas line is passing on that land. That is false, my lordship. I have shown before this honorable court with a sworn affidavit. There is an illegality as to promote that illegality, they are doing that.
What is the main prayer in the petition?
Main
No,
prayer
sir.
in the
Main
petition
prayer,
is
my
for
lordship.
mandamus, my lord. Mandamus to consider their application
My
for grant
application has,
of quarrying lease.
So you decided that.
That is satisfied, my lord. An endorsement has now been issued.
my lordship, that's why, my lordship, I made an application for amending that prayer and to appoint a commission to verify, my lordship, why there is an illegal activity is going on, why they are promoting illegality.
Virtually converting it into a public interest litigation. my lord.
Whatever it
Their
may be,
relief,
my
the
lordship,
writ petition is now
this
satisfied.
honorable court as having the ample jurisdiction to get rid of illegality, my lordship. It cannot close its eyes and say that only on technicalities your prayer has been considered and it cannot be done, my lordship. I have made an application. I made an application to set aside that, quash that endorsement also at present.
So amendment is filed. This is amended petition.
To raise the additional grounds and prayer, my lordship.
Politic, high age grant.
My lord, if as against the relief sought in this application, my lord, against the endorsement, he has a remedy of revision end of the day.
My lordship, how many times public?
That's the statutory remedy, my lord.
Why you are promoting illegality? Kindly
And
answer
all
that.
these things are allegations, my lord. The question of illegality.
Granting interim amendment.
I will leave it to your lord.
Amend you are insulting
Yes,
only play.
Very
Is
well.
insulting a
We
prayer.
will file an additional objection, my lord, in that event.
He is filing only, he is adding only a prayer.
No, my lord, additional facts, additional documents and prayer, my lord, all the three. Lordship may kindly see the application.
But in relation to the prayer,
Please, my lord. Additional facts are also being sought to be inserted.
we will consider 11th.
Please.
11th March. Not grant.
Lordship. Yes. I may be permitted to insert all those
No,
additional.
File your objection.
until we hear no. Yes.
A short date meeting.
Not possible.
Because illegalities are going on, my lordship.
Which
There is
date,
ample illegality. Because of the senior geologist and colluding together, they are making money. My rates has been curtailed, my lordship.
3rd April.
Yes.
You want 3rd April or 11th March?
My lordship.
Which date do you want? 3rd April or 11th March?
3rd April, my lordship, shorter date, it's
So we are
because
asking-
there are a lot of illegality, my lordship. 11th March, 11th.
Can I make one request?
Lord, may I make
Serial
one
number
request, my lord?
78. Any date convenient with the 622 appointments have been stayed at the instance of 5 appellants, my lords. Any date convenient to your lordships, my lords?
Appointment of
622 assistant engineers and junior engineers, my lord. At the instance of 5 appellants, my lord. At 2:30, any date convenient to your lordships, depending upon your lordship's calendar, my lord.
20th March.
Please.
Lordship,
Can I
serial
request
number
2:30?
66, my lordship.
Please,
Remind us on.
we'll remind.
Serial number,
My lord, serial number 78, my lord. Sorry.
On KPCL made a submission that final appointment orders would not be issued until the matter is heard. That understanding.
This is going on since very long.
That's very long time. If
20th March.
serial
My
number
lord, serial number
66, my
78, my lord.
lordship.
Sorry to, my lord, interfere. Serial number 78, my lord. The all are, my lord, retired employees. My lord, they filed for gratuity, my lord. And
Serial number 49.
Yes, madam.
Serial number 66, my lordship.
66. What do you want?
My lordship, the accused has not obeyed the order of the Honorable Learned Single Judgment. So against that, I have filed this appeal, my lordship.
So
But till now, they have not given any response.
17th March, common servant.
Obliged, my lordship.
Serial number 49 is that they have to pay the objections for non-compliance by the government.
40.
49.
Objections matter.
My lords, in this matter, my
There
lords,
is no objection.
may I make one submission in this matter, my lords?
No, no. Office objection matters are not.
For non-compliance by the other side.
In this,
Serial number
in this matter, my lords, may I make one submission?
4 weeks time is granted to remove the office objections, failing which the appeal shall stand dismissed without reference to or order of the court. Then serial number 75. Same order, but 2 weeks.
Lord, 78, my lord, seal number 78, my lord.
Yes, 78. What do you want?
My lord, 78, my lord, the only the objection is that why the first respondent is not made as a party, my lord. That is the only objection. I've given a submission.
I
That means
think
it is
he's
a competent.
mentioning the wrong serial number. 78 is my matter.
Yes, my
I
lord,
think it
78
means-
is a different matter.
Sorry.